May I have your lordship's kind leave to file without certified copy, your lordship? The urgency is that, your lordship, the private respondent is claiming benefit of the deceased son of the petitioner, who was an army
What is the
person.
urgency?
Urgency is
When
not
was
the
the order
benefit. When the order was passed on 2nd of this month, your lordship, it was uploaded on the server on the night of Friday, your lordship. On Monday, your lordship, the petitioner was not well, so she could not come and sign it. Today she has come.
Certified copy, have you applied?
Applied, your lordship. It has been applied, your lordship.
So what is the urgency?
Urgency, your lordship, the benefits will be released anytime to the private respondent. The petitioner is the mother, the only son, your lordship. He was an army personnel, your lordship. Now she is claiming the benefits on the basis of a marriage certificate, which has been issued by the MMR Kazi without jurisdiction. The only son, your lordship. She will be deprived, your lordship.
Granted.
But tomorrow, your lordship.
Leave granted.
Right.
Not tomorrow. Serve upon all those. Serve and complete. It will be day after tomorrow.
My lord. On Friday. Your lordship.
Document.
My lord, Senior Advocate Partha Sarathi Bhattacharya, due to rainy season, could not appear and stand and water in front of your house. Exception has been already ready.
So he can't swim. He can't swim. Not today. Not today.
Fix another date, sir. Fix another
Tomorrow.
No, sir. Tomorrow is not possible, sir. Friday.
But it will be possible for us.
Stand and water in his house.
You know, next Thursday. Next Thursday.
Sir, wear a proper collar. You're not wearing a collar. What
No,
is
I
this?
didn't see. How you are appearing?
Please don't appear like this.
Yes.
My lord, I am led by Mr. Ghulam Mustafa. She passed the order of 26th June. After passing the order, my lord, 5 days delay in SR report, my lord.
Have you served?
Yes, yes, my lord. Both are sir, my lord, Mr. Mitra and Mr. Parthapatim Rai.
You are there.
And for the statement.
Copy date.
Private respondent served. Have you served the private respondent?
Yes, yes, my lord.
Parthapratim Rai.
Parthapatim Rai, my lord. Kindly-
Parthapratim Rai was appearing for the private response, perhaps.
She received, my lord. Notice.
Junior Advocate.
Yes.
Where is he? You people have
I do not
adopted
know whether he has
resolution.
reached or not. Today, this.
Paper.
What should we do? You have taken resolution and you have left it upon us.
That's what. If anybody,
Parthapratim Rai.
Parthapratim, I haven't seen him, frankly speaking.
Day after tomorrow.
Yes.
For the respondent state, my lord, led by Mr. Ghalib.
I am for the petition respondent.
My lord, I am for the appellant, my lord. My lord, today is a difficult situation, my lord. I couldn't leave home, my lord. Lordship would be kindly take up on Thursday, my lord, subject to my lord's pleasure.
Yes,
We have served on all the respondents.
day after. Day after tomorrow.
Lordship, I am grateful, my lord.
This is my appeal.
But before my learned friend starts, Malad, may I just say this? This order was passed on my intervention application. Now, Malad, I have not been served. So I was humbly seeking that if he could serve the copy, then we could also at least join in this pleasure, Malad.
To say,
Malad, this appears from the Builder Corporation, Malad.
Mr. Ray, just hold your breath. Tell me,
He's not opposing Mr. Rai.
Mr. Ray,
I'm grateful then, Malad.
Anyways,
I
no,
just need to point it out, Malad.
anyways, no adverse order. So don't, Mr. Ray, this is a pure bank matter, not allowing bank account operation. I got an order. They made an intervention, one of them, they got it stayed. But in the intervention application, they made out a case of it being a Lodha Birla dispute. That is the whole.
Who is Mr. Ray appearing?
Mr. Ray is appearing for the Birlas.
Lord, I am
For the
Malad, I am appearing for an independent company.
independent company.
My lord, I am appearing for Reserve Bank of India.
Yeah,
It
again.
was the closure intimation served by Reserve Bank of India, which was challenged in the writ.
So that is why, but I have no I should be happy
Copy of the appeal.
Justice Mitro has no difficulty.
But I don't think there is any difficulty.
Lordship, we can have it recorded and Lordship, that is for my lord.
You are appearing for whom?
Reserve Bank of India Banking Ombudsman.
They have not been served, they are saying. Have you-
Reserve Bank of India is party.
Yes, Banking Ombudsman is a
Malad,
party.
that's the way they assume jurisdiction, Malad, in a private banking matter.
Oh, there is no well, service. Yes, we shall affect service. There is no caveat. So this being that is why I thought I should bring it to Lordship has not appeared in. Okay, this is a new matter, but in NCLT,
Malad, there are reminiscences from the Builder Corporation matter. I will agree with that.
If he has raised the issue,
he has raised the issue throughout,
then
all about it.
perhaps
Malad, I've only raised the issue of mostly the maintainability of an order against a private bank in a writ petition.
Ray doesn't want this court to be, this bench to hear.
I want this bench to hear, Malad.
I didn't take the point of estate and all.
I couldn't even think about that there's going to be an appeal from this order, Mr. Mitro.
So that's why you had pre-planned it, Mr. Ray. You had pre-planned it.
I don't think so. The planning is all yours, Mr. Mitro.
There's no mention of Lodha Birla in my petition. You brought it up in your.
I will point it out. Suppressions are galore.
On this court to hear. This is Mr. Ray's doing. All Mr. Ray's doing.
Yes, Mr. I've learned it from you, Mr. Mitro.
Mr. Ray.
I'm so sorry, Malad. Yes, Malad. I'm so sorry.
Mute kore din to.
I'll do it upon myself.
Few of the issues raised by the parties that disputes in the writ petition and hence the present appeal may be linked to the disputes between the two groups, the Birlas and the Lodhas, both being involved in acrimonious litigation. of some kind.
Guru Haji, not ground nut, peanut, banana, coconut. নাট করো না সিম্পল গ্রাউন্ডনাটই হয়ে যাবে
Grounds of
তাহলে ঠিক আছে
after the event practice, the matters
সিম্পল গ্রাউন্ড হয়ে যাবে
let the same be placed before the Honorable Chief Justice. For
Assignment.
Very grateful, Malad. And I'm sorry, Malad. Sorry.
What did you hear?
very grateful he's grateful now lordship sees now lordship what I said is correct.
Malad, this was told to me by Justice Oshim Banerjee when he said that why are you grateful when you lost a matter? I said I am grateful because your lordships had heard me. I'm not like Mr. Mitro. I haven't learned that from Mr. Mitro.
I hope no, not Justice Mitro. No, not Justice.
And I tender my apologies to Justice Mitro because I shouldn't have been speaking like that. I'm so sorry.
4, 5, 16
Separate order করে দিও।
তিনটা আলাদা order।
It and
Grateful, Malad.
Great.
Lordship,
You're there.
I appear for the appellant Lordship. I'm led by the learned additional Solicitor General. He's had an operation yesterday, a minor operation.
Operation.
Tooth operation. So he is not. Just Lordship, sometime next week.
It is that freedom,
It's that, yes, I
freedom
filed.
fighter.
Except this is the freedom fighters pension matter. I have filed a report saying that
When do you want it? Which
Lordship, I've been asked to pray for it, not this week, sometime next week, Mr. Chakraborty.
And if your lordship
That
is
is-
not a 7 except 14.
7 except 14.
14.
Is this to be any scope of interim order?
No,
So what had been the earlier order?
actually what happened was, Lordship, I'm just placing the case in a nutshell. The freedom fighter was not granted the pension.
Pardon?
The freedom fighter who had applied had not been granted pension.
Right.
Thereafter, there were series of litigations, and then ultimately, this High Court says that he's entitled.
He's entitled.
This is where we come in, and therefore, Lordship, we had passed an order in appeal.
Very good.
There was a contempt which the learned judge has adjourned sine die till the pendency of the appeal. So this is the situation.
Now, why 2 MAT?
No, because Lordship, what had happened was during the course of arguments, I mean the
So state and Union of India both preferred
because
independent.
the cost has been imposed on the state
Hmm.
and the Union of India Lordship has been directed to give pension to the heirs. The pensioners, the person, the applicant is there.
Now,
It is there.
what is the stage? They have exchanged affidavits in the stay
Lordship,
application.
they have, Lordship, affidavits were exchanged in the writ. So I don't know
So
whether
there was an order not to proceed with contempt.
there is an order not to proceed with contempt. But Lordship, the appeal needs to be heard. And what happened was during the course of hearing, the learned, there was a submission from our end that certificates issued by
No, we are not on
that
that.
is the, no,
Whether
that is the report that I had filed pursuant to the or
for the writ court.
yes, no, not the writ court, the appeal court.
Oh, I see.
That is why I had filed an saying that the list, because there were 190, the Supreme Court had directed an inquiry into the cases where the person who had granted PKCs had.
Well, I don't like to open my mouth in this regard.
My learned friend have given us.
Well, I will not open my mouth because on that point, Supreme Court has granted
Lordship
pension.
to see.
দাঁড়ার বাবা দেখাবো কেন দাঁড়ানো না করছি অর্জনমেন্ট পিটিশন হচ্ছে অ্যাডজমেন্ট হচ্ছে এখন আর কি আইনের কথা এখন তো ভুল বলছি আমি কেন যে পেনশন দিতে বলেছেন এই যে দিতে ভুল বলেছি
আরে সুপ্রিম কোর্টের অর্ডারটা না হলে দেবো কি করে?
লাইফটাইম এরিয়া নট পেনশন পেনশন হলে এখন দিয়ে দেবে
So next Thursday week.
থার্সডে কত তারিখ দাদা একটু দেখে দেবেন
17, Mr. Manna, 17.
তাহলে 10 তারিখে তো
There are two appeals.
Yeah, appeals, sir. There are two appeals, one by the state, one by the central.
You are for the state now.
Yes.
And item number 9 and 10, I am for the respondent.
Please, Your Lordship. No, any interim order part?
Yes, they are enjoying interim order. that adjudication proceeding before the adjudicating authority at Delhi is stopped because of the interim order.
Have you exchanged pleadings?
Yes, my lord, the writ petition was done after exchanging the pleadings. It is covered by the order of this honorable court.
This stay application has been disposed of.
Stay application has been disposed of.
So there is no direction for filing paper books?
No, because my lord, it is a simple question of law whether quorum non juris, whether a single member can constitute adjudicating authority or not under PMLA. So this is covered by the judgment of the honorable division bench of this honorable court and other courts also. So that was relied upon by the honorable single judge, and against that they are in appeal. Now during pendency of this appeal, they have filed a 7-volume can, which is beyond the scope of the writ petition itself. Now the 7-volume can is on a subsequent development that the predicate offense have been dropped by the predicated court. They are saying that if the predicate offense is dropped, then the PMLA case, the adjudication in PMLA should not even happen. So my submission would be, my lord, that can application, contention in the can, was not within the writ petition, is beyond the scope of the writ petition. The honorable single judge had no occasion to see that. That can be a fresh cause of action for them, but that cannot be a subject matter of this appeal before this honorable court.
So they can agitate the point before the
Adjudicating authority always. That is the whole point.
will dispose of the, we are giving you liberty to raise the issue before the adjudicating authority.
Absolutely.
Lord, I was instructed about this.
Who is your senior?
The advocate and recording officer, advocate.
Who is the senior? You don't know. Huh?
Mr. Billodal Bhattacharya.
Thursday week.
Thursday week.
What remains?
But the issue was, my lord,
You
allowed, thereafter, my lord, we had complied. Right. We had filed an appeal. There was certain observation by the division bench presided over by Honorable Chief Justice whether the writ petition was maintainable. My lord, 8th July's orders, my lord, would find that observations. The order dated 8th July.
Section 5 not allowed.
Yeah, allowed.
Allowed.
Allowed, my lord. There the observation, my lord, starting from paragraph 8, importantly, paragraph 10, my lord. ऑर्डर है हमारे पास, जो ऑर्डर पिछली बार बोला था ना, एक ऑर्डर कॉन्टेम्प्ट का जब डिस्पोज हो
नहीं वो वाला दूसरे मैटर में
Now, this agreement of 19th February 2016 is restricted to this transaction.
yes
So,
restricted.
Mr. Chakraborty, we will dispose of the appeal, and
Difficulty is-
whether this private contract can be a subject matter.
well, difficulty we had complied. Man, according to us, she is not entitled to this. She is not entitled to this. There is an arbitration clause. The writ petition was not maintainable, according to us. That's why this observation came from the division bench.
So, this is an academic issue then.
My lord,
It is restricted to a contract, na? Whether
my lord,
this point
Well,
that
I
whether a
understand.
private contract can be.
my lord, I can understand, but question of if someone, well, at the expense of the states, has been enriched, has been unjustifiably enriched, whether my lord would not interfere into this issue or not.
After you complied.
My lord, after I have complied in accordance with because of the contempt, my lord, it is also subject to correction. It is also, lordships knows, it is also settled. The compliance in terms of a contempt order does not waive my right as regard to my filing of an appeal.
Do it in an appropriate case in future.
My lord,
Yes, Mr. Dotto.
Yes, sir.
আর আমাদের কষ্ট দিয়ে কি হবে?
এই চলে, sir, sorry, sir. I'll show you.
No, Mr. Dotto,
Yes, sir.
we will keep your challenge open in an appropriate case.
Milord, the problem is, Milord, I am suffering. আমাদের প্রত্যেক মাসে দিয়ে দিতে
না না, হ্যাঁ হ্যাঁ, প্রত্যেক মাসে দিতে হয়েছিল, কিন্তু এখন আর নেই, প্রত্যেক মাসে তখন নাও তো ইট ইজ ইউনিফর্ম, আমাকে ডিফারেন্স অফ রেটটা দিতে হয়েছিল।
এই ইস্যুটা মানে আর্বিট্রেশনে কি যাবে?
Milord, your lordships may kindly have a look to the order of a coordinate bench in this appeal dated 8th of July.
Yes, we have gone through it.
Yes. Now, Milord, while allowing the section 5, the division bench, Milord, was pleased to note a few things. Now, kindly have a look to that order, paragraph number 5 of 8th July.
Paper file করে।
I'm sorry, not 5, 7. 7. Well, apropos the court query, kindly have a look to this.
They have exchanged pleadings in the stay application. You have exchanged pleadings.
No.
No.
The stay
no,
application
no,
have
no.
you filed?
Lordship,
Is there
al-
any stay application filed?
Yes,
Lordship,
there is a stay application file, but your lordships
There
may
is
hear
no
out the
scope
entire
for-
matter.
There is no scope for any interim order.
Because I have already paid. I have already paid.
You
And-
file your paper books.
and Lordship, Lordship also in the while before the writ court, your Lordship,
Lordship kindly peruses the order which is passed and the application, the stay application, whether this section, this contract of the clause 26 of the agreement, whether at all a ground is also taken in this stay application or the memorandum of appeal, whether at all that is taken.
That has to be when the coordinate bench has said that for this reason we are admitting the appeal. We
Lordship,
need to return a finding, na?
Lordship, Lordship,
So, but
as your Lordship.
it appears you have used an opposition. What is this opposition to?
Section 5, brother.
Section 5.
So section 5. In the writ petition, affidavits were exchanged.
No.
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 Well, writ and yes, only the writ was there.
Lordship kindly takes the order passed in the writ petition, wherein the state has admitted that we are entitled to the claim pursuant to the enhanced writ, and on the basis of that, your Lordship, they have released the payment.
Exactly. We
Lordship,
will
Lordship,
hear you.
and that's why, your Lordship.
Yeah, we will hear your
Lordship, and
arguments, but
there was no directions given for exchange of pleadings at
no,
before the writ court.
do you want to exchange any further pleadings, or what is there on record is
As your
sufficient?
Lordship directs. As your Lordship directs. Sir, আপনি যা বলবেন। যেটা আপনি বলবেন।
আমি কেন বলবো?
No, there was no direction. Only section 5.
In section 5,
Only section 5.
in section 5, maybe nothing on merit has been stated. It's
Lordship.
only pertaining to the delay.
Only pertaining to the same, your Lordship, and
So
perhaps
you deal with the contention in the stay application. Come with an,
Lordship, as your Lordship directs.
and if you do not want, we will say that to file the requisite paperbooks incorporating the writ petition
Lordship,
and
in that event, your Lordship, I need to answer to the same, because the arguments which are now being made, your Lordship, those points are also not covered in the stay application. The main content, bone of content of clause 26, it is nowhere stated that I have violated clause 26 or clause 26 is not applicable. The only statement made is that single judge failed to consider clause 26.
all right, then use your.
If that be so, your Lordship, then I need
Heard
to.
Mr. Dotto, learned advocate, learned
It's my opinion.
This is the affidavit in opposition with the planning court directed to me. And still now I did not get any reply from them. Sir.
Well, my reply is out of time, and it is being affirmed today, my lord. If I may get an extension up to today, my lord.
12:13.
I've got objection on that point, my lord. Already they have got too much time. It was last order was passed on in the month of May, and this is now July. And they have got it a long time back. It will going to delay into justice. I've got objection. Kindly do not give them extra time.
First May, my lord, your lordship directed the affidavits to be exchanged.
Yeah, Mr. Bandyopadhyay, why don't you? He's appearing in person. For your delay, he has to
My lord,
appear.
my lord, it's true, my lord.
Just
He's
a casual
but it's
appeal.
also, my lord, the days, my lord, when my learned friend has not appeared, my lord. He is also not one of those litigants who have pursued his matter, my lord.
That is separate, but there is an
But
order.
we are only, my lord, we are a bit out of, my lord. I beg your lordship's pardon, my lord.
Have you affirmed it
But it
today?
is being affirmed today, my lord. My lord, only extension
No
up to
objections
today.
from my side.
Just a moment, sir. Without this opposition, maybe you might find difficulty in future. Suppose a point goes off when we are in CC of the matter. Is wanting 1 day's extension, let's say. Mr. Gop
14, my lord, Mr. Dinda is appearing for the appellant, my lord. He was assisting me in the matters, my lord. He just, my lord, he has instructed me that the opposition is outstanding from the
In this
response.
matter, I am appearing on behalf of a respondent, my lord. I also my playing for some time because my opposition is ready, but couldn't affirm due to the illness of the my lord party because he is 63 years age.
So when will you affirm it,
My
Mr.?
lord, 7 days time more given.
Yes, Dinda naam tha diye do.
30th July. Exchange your
38.
30.
Wait for a moment.
My lord, I am for the respondent number 16, my lord. Your lordship has been pleased to direct the petitioner to the appellant to serve a copy upon me with the, along with
that
IIPM matter.
Oh,
Fraud. Lord, I am for the respondent number 16, my lord.
Lord, I am filing affidavit of
Wakalatnama in department.
Lordship, I'm appearing for respondent number 4, 5, 6, and 7.
Then you are appearing for who?
16.
Who is 16?
My lord, 16 has been made a party. I have gone through the writ petition, my lord. I don't have a copy. 16.
Millet copy was served earlier several times. They are not appearing. And Millet direction for service upon the 6, 7 has already been made by speed post. By speed post, this has been received by them. And appearing. 6, 7 appearing.
6, 7
No,
are
they are
appearing.
Oh,
appearing.
6, 7 appearing.
Who is 14? Who is 14? You are for whom?
My lord, I am for respondent number 16, my lord.
14, Lord,
16 is the, my lord, purportedly, my lord, he is the dean. He has been made out to be a dean. Actually, he is not the dean of the institution at that point of time. He was not. My lord,
Even,
he was just an employee and imparting education to some of the students.
even 6 and 7 are not associated, Lordship.
They are not.
They are not. They were never the directors of the 4 and 5. I can put some papers on record. And
Give a copy to me.
6 and 7, Lordship, as
copy them.
as put in the memo of parties, Lordship, we have never been the director during the time of during 2012-13 or thereafter.
So
Lordship, at
you
any
are
point
not
of time.
representing 5.
5 we are representing.
Then who is your director? Present director?
Ratul Kumar Shom is the present dean, present director. Yes.
Then what
Lordship,
is
it is
the
on
problem?
record. We have filed the governing body list here.
No, right, but you took the money from this person.
The institute, Lordship, that we will file in reply. We will put
No,
everything.
not reply. You are sitting tight with the money.
Lordship,
The
he has been
person
given.
went and found it has vanished in thin air.
He was a student of 2000 during the course of 2012 and 15. He has already been given the mark sheet. There was a direction by this honorable court that compliance report is also to be filed. Whether he has collected the mark sheet or not. He has got the.
Who will give the degree?
That Mahatma Gandhi University only, Lordship, because there was a tie-up with Mahatma. He was enrolled with Mahatma Gandhi University also because we were
Where
not.
is that degree? Where is that degree confirmation?
Lordship, may kindly see the order dated 7/4/2025.
কি বলেছে?
Yes, Lordship. Appellants were directed to collect statements of marks also. And whether he has para number 4, Lordship, of the order dated 7/4/2025. Before we proceed to examine as to, my Lord, before we proceed to examine as to what direction has given in the writ petition, we direct the appellants to approach the concerned police station and collect the statement of marks which is stated to be lying with the police authority and report this court about compliance with the said direction. Whether they have taken it or not, we are not aware about it, but there was a direction from this honorable court to collect the mark sheet also. And his course was completed before that.
That is not relevant. May I?
But several hundreds of students were
Yes.
My lord, remember on that day, my lord, Mahatma Gandhi University has issued a BBS certificate, which has no relevance with IIPM. The Vice Chancellor of the Mahatma Gandhi University has specifically stated, we have no relation, we have no contact, we have no agreement with IIPM. So that is a piece of paper.
But how come?
And in my affidavit of exception, I stated that I have no relation with Mahatma Gandhi University. I never admitted to them. I never paid money to them. The
Now,
money,
what do you want today? What is your prayer now?
my lord,
Present position, what is your prayer now?
my prayer is referring this matter to CBI. This is, my lord, this is third times, my lord, investigation has been made, which is not properly made. Third times it has been made. It is perfunctory investigation that is proved before your lordship. On other day, I have made submission, and today I may submit your lordship further. But it is the clear proof of commission of fraud by IIPM against the petitioner and other students also. But the petitioner is my client, and they have taken 18 lakhs. 18 lakhs. Now they have closed the institution, and then they have to justify their compliance. They have
What has
issued a
happened
Mahatma
to
Gandhi
the-
University mark sheet.
What has happened to the criminal case?
Like
Lordship,
criminal case,
Final report.
two times FRT has been given. That has been challenged.
2 times?
FRT has been given.
Not 2 times, 3 times, Lordship.
And that after
After it was they have filed a writ petition. In writ petition, there was direction for
now the investigation is over. What
Yes.
will CBI do?
Well, that investigation that is the perfunctory investigation. No,
Against that FRT, did you file Nadaji?
well, initially that was filed before the court, the criminal
What
court,
had-
and thereafter it has been filed before the.
Please try to understand. You have lodged a complaint. On the basis of that, the police authorities have conducted an investigation and filed an FRT. Have you filed any Naraji to that
Yes, ma'am.
FRT? Then what had been the order?
Pursuant to Naraji, second investigation has been done.
After that also FRT.
FRT.
Then what you have
Thereafter.
Writ petition filed before this honorable court.
what will the REIT court do? After the investigation has culminated in final report, what will the
It will
REIT
be
court do?
re-investigated by CBI,
Even after.
because they are not.
Oh, you have not challenged the second FRT.
Yes, my lord. My lord, second FRT.
Show us any authority that without filing Naraji petition, you can come to us and say, now send it to CBI.
How many times I am asking myself, how many times they will file the FRT? One FRT.
So if there is an FRT, sir, there is a procedure.
My lord.
If there is an FRT, first FRT was filed, there was no, that was set aside and a further investigation was directed. That has also landed up in a FRT. Then you came to the REIT court.
Upon filing of Naraji before the criminal court. Upon filing of Naraji before the criminal court. Second time Naraji was.
After the second FRT which you have, which have been passed, filed, to that FRT you have not filed any Naraji.
Second FRT we have filed in Naraji.
So what is the status of that?
They have done nothing. The file is
If Naraji is filed before the concerned criminal court,
my lord.
do you know whether any order has been passed in that?
My lord, my information, no order has been passed. File is not traced out.
Mr. Shortcut, try to understand. When the investigation is over and a FRT is filed, and if you have approached by filing a Naraji, we have a right to know what has been the fate of that Naraji. If in that Naraji petition has been rejected, there are other remedies available to you. But you may argue that I shall not go before that, I have come to the REIT court. But we must know the status of the second FRT. Did you file Naraji? Have you,
I filed Naraji.
can you
Then
show us the order?
Upon information, I have to state the status.
Please tell us the status. Otherwise, it will be a jumbled investigation. Na? Did you say that before the coordinate bench?
Yes, my lord, coordinate bench also passed an order directing them why the matter to not be sent to CID. They have satisfied, the coordinator has satisfied about the
Who is for the state? Who is for the state?
Mr. Krishnendu Banerjee on the last of.
My lord, I am appearing for the UGC one. My lord, kindly see my affidavit, my lord. I have stated, my lord.
Mr. Shishanu Bandyopadhyay was there. Where did he go?
রিটের অর্ডার ফার্দার ইনভেস্টিগেশন সেই হ্যাঁ এবার ফার্দার ইনভেস্টিগেশন দেওয়ার পরে বললাম ওই অর্ডারকে চ্যালেঞ্জ করে এলাম আমরা কিন্তু আর নারাজি করলাম না নামটা বলে দিই।
That kindly have a look to page 24 of the stay application. It could be directed for further investigation.
এলো কি করে এলো কি করে আমি তো কিছু অর্ডারটা কিছু কপি নেই আমি বলতাম আমরা তো নেই করে হ্যাঁ না ঠিক না সার্ভিস করতে ভুলে আসছি পুলিশকে ডেকে এনেছে তাই আমি পেয়েছি মধ্যে অর্ডারটা ইনক্লুড অর্ডারটা কি চ্যালেঞ্জ কি করেছে এইটাই সিঙ্গেল বেঞ্চের অর্ডার এটা পুলিশকে তো পাঠিয়ে দিয়েছিল
Achha, did the inspector in charge file the report as called for by the earlier order dated 7th April?
Yes, against they have filed report before the coordinate bench, and against that report, I was allowed to file exception.
Exception.
That
You
I
have-
also filed. Last occasion, I also explained the contentions of the exception. I have clearly stated that the with bypass to the compliance of their duty, they have showed the mark sheet of Gandhi University, which has no relevance in.
Have you gone through the earlier order of 7th April?
7th April, yes, Lordship. 7th of April, Lordship, the appellant was directed to collect the mark sheet.
So, no.
We have not
Mahatma
received-
Gandhi University has stated that it had no relation with your institution.
Lordship, may I submit that there were hundreds of students from, who were.
We are not concerned with that. We want to know what was your
degrees were
relation with
given by the degrees were given by the Mahatma Gandhi University only. There was some tie-up with them actually.
What tie-up? Show us.
Understanding, that is the
That has been
understanding.
disbelieved by the court.
Lordship, there were hundreds of students in that during that course. 12 to
We are
15,
one-
only one person has come out, and
maybe.
we are giving him. Actually, from MGU, the
Show us what tie-up you have with Mahatma Gandhi University.
Lordship,
Because he was taken in on the pretext that the degree will be given by you.
Lordship, actually, we were enrolling the students with the Mahatma Gandhi University, as well as we were teaching here also.
Show us.
Degrees where we were directly admitting actually.
Show us that you had any agreement with Mahatma Gandhi University in the year 2015 when this person was at.
University has been by the party here. They can always
Forget about them. We are asking you.
Lordship,
You have to establish that you have genuinely inducted them.
Lordship,
You have taken the money of 18 lakhs.
Lordship.
Your question, your argument is that I will not be giving the degree.
Yes, Lord.
Degree will be given by Mahatma Gandhi University.
Yes, Lordship.
UGC has not recognized you to be
That
an
is-
institution competent to confer degree.
Yes, Lordship.
So you are saying that I am tagged with Mahatma Gandhi for the purpose of giving degree to the students whom I have admitted. So this must be based on records. What is the record you have to show that Mahatma Gandhi University is a tie-up with you, that you will give training, you will teach them, and Mahatma Gandhi will give the certificate, registration certificate, will give the degree. Where is that?
Lordship, the thing is that we will have to search it because now the institute is closed. Just I'm just submitting, and they're not finding.
student of MGU.
Yes, Lordship.
No, never. In affidavit, I have stated.
He has
Look
been
at the
given.
records. Don't say no, never. Look at paragraph 4.
Yes, my lord.
Read
Yes,
it.
Abhishek Mukherjee was a student of Mahatma Gandhi University, Meghalaya in the year 12 to 15. Mark sheet enclosed.
Right.
My lord, they are stating, my lord, in the earlier paragraph.
Paragraph number 2. They are
No.
saying, Sarkar, they are saying that they don't have a tie-up with IIPM or there is no merger, whatever. However, in the same breath, in the same letter, they admit that Abhishek Mukherjee is a student of MGU.
My lord, we are denying that.
We never took admission
We never took admission.
in under Mahatma Gandhi. We were the student of IIT.
Mahatma Gandhi
Only
University.
student of IIPM.
Mahatma Gandhi University is a party here.
No. We do not know about Mahatma Gandhi University prior to the this report.
No, did you not receive the mark sheet?
No, mark sheet I have received.
And the certificate?
There is no certificate, only mark sheet. They have received, which is telling that they were the student of 12 to 15. But kindly have a look.
No agreement.
No agreement. Abhishek Mukherjee, Premananda Mukherjee, son of Premananda Mukherjee, was a student of paragraph 3, my lord, of that report. My lord, page 35. Yes, Abhishek Mukherjee, son of Premananda Mukherjee of 47 Kamalpur East, post Kamalpur, PS Damdam, was a student of our university in the year 2015. Well, prior to 15, he was not. My lord.
আমরা এই বলছি
Oh,
পেজ নাম্বার বলছি
well, page number 35 of my exception affidavit.
Yes, we are on that.
exception to the
Once they are, the Mahatma Gandhi University saying that he is the student of in the year 2015. Next paragraph, they are saying he is the student of 12 to 15. And next paragraph, they are saying we have no merge agreement with IIPM.
we never took admission in
We never took, in the affidavit, we said that we never took admission in a Mahatma Gandhi University. We have no relation with Mahatma Gandhi University.
Is he was he a student under you?
Yes, Lordship, but the since we did not have that UGC thing, so we were
The mic. Take the mic.
The mic,
Yes.
mic.
he was a student of IIPM, but the degrees were given by because Mahatma Gandhi University is a recognized university. We had understanding with them. We were enrolling the students.
This is what we
This
want to
is
know.
what we are.
Actually, we were enrolling the students with Mahatma Gandhi University.
What is this understanding?
Lordship, Mahatma Gandhi University may also be implicated here.
No, first you tell us what is this
That
understanding?
we were enrolling the students there. They were getting the degrees from there at that point of time.
Show us some document.
Lordship, now since the we are not having at present, we are not having any document. Actually, there was because of the change of.
Listen, don't escape from the question of the court.
I understand, Lordship.
You have admitted the persons, maybe 1,000 others.
Yes.
Upon receiving money, what did you tell the students? That I will not give you the degree.
Yes.
Degree will be given by Mahatma Gandhi.
Yes, Lordship.
Show us that communication or that letter that though I am admitting, I am taking the money, degree will be given by Mahatma Gandhi. Show us that.
Lordship, we will file with reply then.
No,
Because
sir,
we
you
have,
cannot escape. Matter is
we will submit everything on record, Lordship. That
no, not I will. We will ask who is your dean? Who is your dean?
dean, my lord, purportedly, my lord.
No,
Wait, we have
not
not
yet.
asked you.
Huh.
Who is your dean? Your organization is not existing presently,
Not existing presently.
right? So you have already wound up your business. Nobody can come. Now you have escaped. You have taken the money. You have left them in the lurch.
My lord, may I submit one?
Wait, we will ask you. Who is your, when did you wound up your business?
There is no student, but the organization is there.
Organization? Who is running the organization?
Now the society is lordship. I have provided. I have submitted documents. Just 1 minute, please.
Tell us who is the
Who
society?
is the director? Ratul Kumar Shom is the director here. Now there is no dean because
He is the
director.
director of IIPM.
IIPM. Yes, lordship.
From which document you are saying?
Lordship, the last page of that document I have just submitted before this court.
You ask all your members to be present in court. Because you are not being able to satisfy us that you have admitted the person on the basis of an agreement with the Mahatma Gandhi University. We don't know Mahatma Gandhi University. We know you because you have taken the money.
Yes, lordship.
So your directors have to come before us.
We will
Because
file
you
an
have
affidavit.
failed, because you have failed to show that there was any such agreement with Mahatma Gandhi University towards conferment of degree upon the students whom you have admitted. Understood our point?
Lordship.
Mr. Gupta, what have you stated in your affidavit?
I have already public notice, kindly see 219.
Now, please tell us now. Mahatma Gandhi University has existence.
No. I have no regarding IPM, my lord. I clearly stated that he is not, this institution not recognized, neither to award any degree or a.
Right. Then is there any existence of Mahatma Gandhi University?
That I can't say, my lord. Regarding IIPM, I have stated at this stage. At my lord.
Should be given a chance.
One night.
My lord, BBA and MBA. MBA is the graduation degree.
You opted for the graduation degree?
My lord. And they have supplied only the.
You were a student for graduation degree. You were a student for degree course, not a diploma course.
No.
Not a diploma.
My lord, I passed ACES. Thereafter, I admitted to their institution for having BBA and MBA degree according to their.
And not at the same time. MBA is Masters of Business Administration.
My lord.
BBA is Bachelor of Business Administration.
Yes, my lord.
So you took admission must be for BBA.
That package course they have advertisement in their certificate admission of certificate.
You tell us you were admitted in BBA or in MBA.
BBA and MBA both according to my papers. BBA and MBA both. Admission. Kindly have a look to their admission.
Come to page 37 of your stay application.
Of the exception.
Exception,
my lord.
মনে হচ্ছে
পরে
এটা আমাদের কাছে একটাই আছে।
It is final report.
There was no
Yes, see, if you see that box,
My lord.
that box at page 37. See the first serial. Original certificate of graduate diploma in management in the name of Abhishek Mukherjee of IIPM.
My lord.
So there is a certificate in place.
এটা ওরা দিয়েছিল। They have
Malak-
given to the police.
They have given to the police.
They have seized them.
They have seized them. They have given to the police.
Page number 38. Page number 38 এই জায়গাটায় লেখা আছে।
I'll kindly see page number 38, second paragraph.
Keep quiet. Somebody is arguing. Don't jump up on his shoulder. Take your seat.
Yes, I've seen. He was left to receive the certificate. It says Abhishek Mukherjee, one of the students of the institution, had left to receive the educational certificate from the institution. Second paragraph, last 4 lines. Last 4 lines.
Representative has produced the educational certificate.
But anyhow, Abhishek Mukherjee, one of the student of our institution, had left to receive the educational certificate from the institution on 10/9/16. Educational certificate of Abhishek Mukherjee produced by the representative of FIR. Representative of FIR named accused person Rojita Mukherjee, and these were duly seized and kept to PS. That is the certificate. Initially, I have not received, and thereafter they have supplied through police station, police authority, pursuant to order of.
So there is a certificate waiting for you.
Well, that certificate I have annexed also. That mark sheet only.
What you have annexed to the, yes, what you have annexed to the statement of marks, not the certificate. That certificate is
that only that statement of marks have been supplied. No certificate has been issued, neither they have supplied.
Now, if that is the grievance, Lordship, we can assist him in getting. We can assist him in getting the certificate if he has not received from Mahatma Gandhi University. Because since he has got this statement of marks, then he can get certificate also. We can assist, Lordship.
Well, kindly have you look.
You have no relationship with Mahatma Gandhi.
Lordship, the thing is that.
Then how will you get a degree from Mahatma Gandhi University to be awarded to him?
Lordship, it is the case of the appellant that they have not enrolled with Mahatma Gandhi University. It is us who have enrolled it, not only him, but thousands of students or hundreds of students who have already got and who have never come or complained against us, basically. It is the single case where we have got the complaint.
Why? What? Then the complaint has to be satisfied.
Because complainant is to be satisfied. Because
you show us any degree of a student who took admission on your part. UGC says that you have no jurisdiction to confer any degree.
Lordship.
So degree can be conferred by a university. You are not a university.
Yes.
So you show us that there was a tie-up between you and Mahatma Gandhi that I will admit, I will give teaching to them. Final assessment and conferment of degree will be done by Mahatma Gandhi.
Lordship,
if you cannot establish this,
it is the case. Lordship, may I?
You answered our question.
Lordship, I am answering that only.
Where is the agreement you show us?
Lordship, agreement we have to. Then I have to take the instruction.
No agreement.
Lordship, maybe or may not be. I don't know. I have to take the instruction from the client. But the thing is that it is the case of the student only that he was learning in the Indian Institute of Planning and Management, and he was being given the statement of marks and the degrees, I mean the certificates from the Mahatma Gandhi University.
I understand your contention,
so,
but
maybe a formal agreement.
Your contention.
There may be a formal or informal agreement, but I have enrolled him.
Saying, sir, there may be a formal agreement, there may be an informal agreement.
Because, Lordship, they are saying that they are not enrolled with MGU on their own. It is us who have enrolled them to secure his recognized certificate.
Exactly. Show us that agreement. Finished. We will say you go home. You show us that.
Now, Lordship, even there is an. Let us assume that there is no agreement also. But I am saying
don't take two stands. Either you say that yes.
Lordship, then I will file an.
Don't disturb him. Either you make your submission or let him allow him to do. Take your seat. Take your seat. Sir, what is your name?
Ratneshwar Das. Ratneshwar Das.
Mr. Das, your contention is that Thousands of students like him has taken admission in IIPM. They have studied the course. Mark sheets were issued by us. They have received it. Nothing, no problem.
Yes.
After the conclusion of the course, Mahatma Gandhi University, with whom you were having a tie-up, had given the degree to those persons. This is your story.
Yes, Lord.
Now, if you can show us any agreement to that effect, whether anybody has raised protest or not, that is an other side of the story. We want to know that how you admitted and what tie-up you had with Mahatma Gandhi.
Lordship,
Show us those two documents.
Lordship, in this regard, may I submit that my institute, actually, our governing body is there, my organization is there, but my institute has closed down. That is the fact. We are not enrolling students as of now. But here, the appellant has made all the efforts to implement unnecessary parties, even including Shah Rukh Khan also, HDFC Bank also. But
Answering our query. You are not, don't escape from our query.
No.
We have asked you a plain and simple question. Show us what document you have to establish your relationship with Mahatma Gandhi.
Lordship, that's what I'm submitting, that I am, since I will
So you
take
cannot
instruction.
produce.
Mahatma
you-
Gandhi University may be directed to do
No,
that.
we will direct you. Money was not taken by Mahatma Gandhi. It was taken by your institute. Money was taken by your institute. Either you show us your relationship or we ask all your directors to be personally present in court.
We will show, Lordship. Lordship, I will file a counter
No,
affidavit.
service will be done. We are recording. You have to produce that document before us. Along with your director now. He will be personally present before us.
He is based in Delhi, Lordship.
Ask him to come. He should be here.
At least 4 weeks.
And who are you appearing for, Mr.?
My lord, I'm appearing for the respondent number 16. My lord,
Name.
This gentleman name is Aniruddha Banerjee. Aniruddha Banerjee.
Respondent number 16.
My lord, he has been implemented on the plea. Respondent number 16, my lord.
The name to
I don't have the copy of the memo.
That Aniruddha Banerjee.
Yes, my lord, he has been implemented, my lord, on the plea that he is the present. He was the dean at that point of time, which is untrue, my lord. Which is untrue, my lord. May I submit that Omlan Rai, who was the dean at that point of time, my client used to take classes in the institution. I can provide the names of
admission. Kindly come to page 37 of the exception. Which was the, have you filed a show cause? You have filed a report. Where is you have filed a report? Report by officer. Acha, show us page 37. Kindly come. 37 you got. Where is Mr. Shirshanno Bandyopadhyay? Read original certificate of graduate diploma in management in the name of Abhishek Mukherjee of IIPM. Where is the certificate?
My lord, for our request, my lord, Mahatma Gandhi University.
জানে না এরা কেউ অ্যাসিস্ট করে না।
Some mark sheet, my lord, but no certificate, my lord.
That is what your officer has stated. Officer states that there is an original certificate of graduation.
You have only the mark sheet, my lord, no certificate, my lord.
Then why this was written? Property description, page 37. Got it?
That mark sheet was handed over to the appellant, my lord.
Degree we are saying.
I understand, my lord, but that's not the task.
Original certificate of graduation. Where is that certificate?
No, no, that's also there in your report. What are you saying, sir? Second part on 10/9/16. Providing Balaji report of
Report in the হ্যাঁ এইটা কি আরেকটা রিপোর্ট
আবার
কি বলেছে
হচ্ছে on 10/9 SI Proving seize original certificate of graduate diploma in management name of officer by IP. It's a mistake now. Certificate
to degree.
Original certificate of graduate diploma in management.
Kindly permit me to assist one thing. Kindly have a look to page number 22 of my exception. This is the certificate issued by IITM.
Page.
Page 22.
Of your exception.
Affidavit of exception. In each document, it is clearly stated they have taken their admission on the course of BBA plus MBA.
Page 22.
22 of exception, annexure P2.
We are talking about the certificate of graduation.
Certificate has been issued. This is the certificate of admission issued by the IITM, stating that they have taken admission in the course of BBA and MBA.
Okay, so I have written a statement of marks.
You call Mr. Shishanna Bandyopadhyay. Where is he?
Probably he is in court number 26. I will inform.
No, you go outside, give him a ring. That court wants his presence.
As per the following order, investigating officer has returned the following documents. The document, original statement of marks.
কি বলবে বল Mr. Gupta, how is this degree conferred? What is the pro forma of degree conferment?
Degree, my lord, under section 22 of the Act. Kindly see page 219, my lord. I have 219
219 of what?
of the step. 22, subsection 3 of the Act.
এটা কি গো?
Public notice dated, my lord, 2000 July 2000.
200 and
219. 219.
চাইলে আর এই প্রশ্ন মাথা ফাথা খারাপ হয়ে যায়।
Who is instructing you, Mr. Das? This IIPM? Who is instructing you? Who is the person?
Ratul Kumar Shom is the director of IIPM. Ratul Kumar Shom.
Ratul Kumar Shom.
Yes, Lordship. I have submitted the governing body list also.
Where? Page?
Today only I have. That is the last page of the document filed today.
This one you filed?
Yes, Lordship.
What is the first
para number 2? The first is the registration certificate of the document, and I have submitted it to show that
Arun Kumar Bose, he is no longer a member.
No. That is of 2012 only.
That is 2000. Now, what is the present?
Present is Ratul Kumar Som, director.
So either you will show us the agreement you have with
Lordship.
If you fail, this Ratul has to be before us.
Yes, Lordship.
So you know we have served. You were not participating in the proceedings. Service was affected. You did not turn.
Lordship, we have received an email. Actually, now only we have received.
Me, my lord, respondent number 16, my lord. The address on which the post was sent.
So now you have no relationship with IIM.
Neither then, my lord.
Uh-huh.
Neither then in 2012.
Very good.
I used to work in the sister.
Mr. Das, you ask Mr. This Ratul Som to be here, personally present before us.
We will file affidavit, and if we fail,
no. We want his presence.
All right. Lordship,
because you have, in spite of our order being communicated to you, you have not come with appropriate instruction.
Lordship, there are two unnecessary parties also here.
That we will consider later. Either you produce the certificate or be sure we will not be leaving you then. 18 lakhs you have taken from the student.
But we are giving the certificate also. The fact is that maybe we have
practiced fraud then. You have admitted the students without yourself. You knew that I cannot confer the degree. When the time of admission, you took the money, you gave them admission, you conducted some classes. And at the end of it, you said, go home, no degree given. Unless you satisfy us, we will take appropriate coercive steps against you. Be sure about that.
Lordship, we will try. He is the
Chaudhuri.
Lordship. Lordship.
He's the main director.
He is not the main director. Lordship may kindly see all these documents. He
You are
has never
appearing
been
for
the
6. You are appearing for 6.
Yes.
Arindam Chaudhuri, you are appearing.
Yes, Lordship.
Yes. Now he is not, your institution is not there. What director will be there?
No, he is not there. Yes. No, director is there. I mean, the organization, the society, that was the certificate of which I have already submitted. Society is there, but the society was having that, was running that institute. There is no student now. I know.
বলো ওটা আমি ডিকটেট করে দেবো আর কি নেই বলো no affiliation or agreement or any
when he has been designated as director, he has actually it's the same way that Shah Rukh Khan was used as a brand ambassador. His name was also used by the director because he was a ex-student
Mr.
of.
Bandyopadhyay, in your report, I don't know whether you have checked it up. We find that your investigating officer has said that he has collected, he has seized the. But that certificate, that is not referred to your exception, the report which you have filed.
And also not in the coordinate basis order to return.
Yes, that was also not there.
But inquire whether it's still there or not.
No, you have stated in your petition that you have seized that.
Only FRT minute I can see.
Original mark statement is one thing, and original degree is another thing.
I can see. But I'll require some time to.
Pursuant to our earlier order, We will take app.
My lord, I also need a set of the copies, my lord, of the memo and the CAN applications, my lord.
Yes, give a copy to him. Mr. Das, please consider.
I will.
And if at all there is no document, then something has to be done about the money.
We will come with,
No, as you are our officer, we are taking.
yes, Lordship.
As you are our officer, suppose today the documents are not there, but the factum of 18 lakhs is there.
I understand.
So now you are wise to decide what you will do.
Lordship.
If you can come with some any other proposal, we shall consider.
Got it.
That is good. That is good.
Yeah. I can.
Item number 16, my lord. London Advocate record, Mr. Torun Kumar Das is suffering from fever, my lord. He could not come.
Your
Praying
Lordship,
for
I have been
accommodation. I have been instructed, my lord.
Lordship,
Praying for accommodation for this week, my lord.
Lordship, I would just like to file my exception to the supplementary affidavit that they have filed. I shall serve them a copy. Let us come back on the. Lordship, I have handed over copies to my learned friends.
Item 17, my lord, I'm happy. Kindly have a look to the preamble. My lord, may I please your lordship? Your lordship may kindly take the defect. Some defects are appearing, noted by report dated 4th April 2025. One is with regard to delay. I have filed an application. The third one relates to adding of a respondent number 10. Kindly have a look. The first one, I have already filed application for condonation of delay. The second defect and in 12 can be cured, my lord, by just bringing this respondent as party who has been too missed out.
But with so far as respondent number 10 is concerned, I have filed an application so as to bring him on record, because the status of this respondent number 10 and the appellants are same. There were 6 private respondents. 5 of the private respondents filed the appeal. One possibly, my lord, was not available, for which the defect has cropped up. To remove the defect, I have already filed a can, my lord, so that Makhon Lal can be brought on record.
Makhon, where is
Makhon
can
Lal,
number?
respondent number 10.
Can, what can?
Can, কত can? আমার হাতে লেখা আছে। Can 2 each condonation of delay. Can 2 each condonation of delay. Can 3 each to bring on record Makhon Lal.
3 times.
And the other can be corrected by advocate on record, just formal, just
Can 3.
Can 3 each for bringing on record Makhon Lal, who is a private respondent suffering the order in the writ petition. 5 of the private respondent have filed the appeal. 1 was not available, so his name should be there in the cause title as respondent, not as appellant. The condonation of delay is, my lord, can 2. And the other defect are formal, which can be, my lord, cured by the advocate on record. This relates to defect. Now, my lord, with regard to main matter.
Just a moment.
I'm sorry. Memo.
Who is respondent number 10?
10 is, my lord, Makhon Lal Sarkar, who was a private respondent along with these 5 appellants.
All right. Pleading of the writ petition. Respondent number 10 ছিল one of the private respondents in the appealটা যখন বলবে ওর থেকে পটার্নিটিটা পায়। So why such a long order has been passed by the register? Have you gone through this order?
Yes, my lord, I have noted that. But in fact, I find, my lord, that though it's long, but these are formal only, which can be cured by advocate on record itself. Because these are not.
Which is to be cured?
Now, my lord, so far as condonation of delay is concerned, we have already.
Please don't repeat. We are asking which defect has not yet been removed.
My lord, my lord. Can number 2 to bring on record
All right, that
number 10.
10. And for 12?
And the other is to bring on record 2 respondents, 1 executive engineer and 1 project manager.
Were they parties in the writ?
They were already parties in the writ petition. They were parties in the writ petition. Their name inadvertently.
Is the project director and
My lord, it records as executive engineer Nodia
that is
and
respondent
project
number 5.
manager, respondent number 3. That your lordship will get at page 128. That is the cost title of writ petition. Respondent number 3 and executive engineer. 12, 3 and 12. Kindly have a look.
They were in the memo of appeal. Executive engineer was there in memo of appeal.
Then it's not
Respondent of the project director was not in the cost title of the impugned order. Project director was not there in the writ petition.
My lord, project director was not there in the writ petition, but by virtue of the impugned order, he has been added. Therefore, now I owe a
He has been added by which order?
My lord, by the impugned order, which is assailed before your lordship, the project director has been added. Therefore,
was that he has been added?
My lord, that is 12th July, last order your lordship will find. After disposal of writ petition, he was added. Kindly have a look to order dated 12th July 24. Therefore,
12th July.
12th July 24.
We don't find any order of
Memo of appeal your lordship will find. Memo of appeal and
read court order. You are showing us the read court order.
My lord, there are two read courts order. Yes, my lord, read courts order.
February.
Read courts order. In the memo of appeal, your lordship will find. In the memo of appeal, there are two orders. Kindly take trouble. I am sorry, my lord.
No, you are saying that project director was added.
Added after disposal of writ petition. So, because he has been added after disposal of writ petition.
Show us from the order.
12th July 24.
Show us from
I'm
the
sorry.
order.
May I read, my lord, the order?
Not the whole order where it was.
An application has been filed by the writ.
Just show us that portion where he's added.
Kindly, my lord, learned advocate. One line I will make. The learned advocate for the writ petitioner files an application for addition of party to the extent that the project director, West Bengal Highway Development Corporation, be directed to take steps, and two applications were filed, Can 1 and Can 2, by the writ petitioner. Both these applications stood allowed by the impugned order. By the impugned order, one application was to add project director as addition of party, and by the other to recall the main order passed in the writ petition. The main order passed in the writ petition has also been recalled, and an order of addition is passed together with direction also passed by the same order. Something strange, my lord, because after disposal of writ petition, now, my lord, there lies the point. After disposal of writ petition, to what extent these applications can be entertained and an order be passed on these two applications. These are because these are post disposal of writ petition. The writ petitioner came by filing an application. Kindly recall the earlier order. That order was recalled at the instance of writ petitioner. The other application was kindly add project director to be a party. Project director was added. And on project director, the direction was issued. Therefore,
then what then what happened? Project director passed an order.
My lord, the project director, what happened?
What was the first order?
Kindly have a look to my lord, the first order.
That is 7th of February.
7th February 2024. Kindly take trouble to look to, though this has already been recalled, but kindly, my lord, allow me to place two paragraphs because this is in modification of that. My lord, may kindly, page 2, Mr. Roy, learned advocate for the private respondent, raised strong objection as to maintainability of the case, particularly in view of previous court's order dated 27/6/2018, passed in WP number 2012. He says that The self-same cause of action has already been finally decided by dint of the said order by a coordinate bench of this court. That self-same issue cannot be agitated for the second time by dint of the writ petition. Milord, pausing here for a moment, kindly, Milord, allow me to place it. This writ petitioner on same cause of action filed this writ petition, which was dismissed by a coordinate bench of my Lord Justice Mantha upon exchange of affidavit and on contested hearing. On contested hearing, the earlier
that order.
My Lord, may I just, I am page 8299 হবে দেখো তো 8299 and
Writ petitioners are here.
yes, I'm yes.
State
Kindly come to page
State.
89. I'm sorry. Kindly come to Milord. I will allow him to. This writ petition was filed by the same writ. I'm sorry, page 89 of the stay application.
89.
89 of the stay.
That printed number you are showing.
10-1 of 25, that is stay application, where your lordship will file on annexures. I'm
The page initial is not telling. Page 80.
Page 100, I'm sorry, my lord, I'm sorry, 110. There are two page number appearing, I'm extremely sorry.
Page 110.
Yes.
It starts from
It starts-
113.
It starts from 13. It's order dated 27th June 2018.
Yes.
Kindly, my lord, take trouble to. The petitioner is aggrieved by unauthorized construction on land belonging to Kollani Highway Subdivision under Highway Act. The petitioner submits that such unauthorized construction is being obstructed to free ingress and egress of his land. In the affidavit of the respondent number 4, a report has been annexed to suggest that free ingress and egress from public road to premises of writ petitioner is not obstructed. Such report has been filed by the executive engineer of PWD Kollani Construction Division. The writ petitioner cannot therefore have any grievance with regard to such construction. However, if the authority finds their land is being unauthorizedly used by private respondent, they may take steps against the private respondent as they may be advised by the law. With the above observation, writ petition must fail and is dismissed. Now, my lord, this was done on exchange of affidavit. Now, if your lordship looks to the impugned order, there is not a single line considering, and moreover, this order stands already recalled by the writ petitioner after disposal of the writ petition. While this order was passed 7th February 2024, my client preferred an appeal against this order. When it was under appeal in the division bench,
order
7/2/24.
Please, you have not finished with that order. Tell us what was happened in that order.
In 7/2/24, page 2, my lord. The operating parties let this writ petition be disposed of.
So
with
your
direct-
first point is when it was decided, this
Earlier, it attained finality.
finality it attained, but there was a
To some
rider.
extent, of course, with that rider,
So on that basis of that rider, they have filed a fresh representation.
no, there lies, my lord, the point. It is not on the basis of rider the writ was filed. That your lordship will find.
Subsequent to the order of 27th, the representation has
I am
page 3 of the order.
page 3, my lord. I am let this writ petition be disposed of with a direction upon the concerned
Read the
respondent.
previous
authority.
paragraph.
In doing so, he will.
Previous paragraph.
Yes. It appears that subsequent to order dated 27/6/18, a representation has been made by writ petitioner before the authorities on 9/7/18. Now, my lord, 9/7/18. Let this writ disposed. Now, this order,
No, thereafter he filed a recalling application.
this writ petitioner filed a recalling that this order is required to be recalled.
And direction needs to be issued upon somebody
Two
else.
applications, yes. Two applications were filed. One just to recall this earlier order because he was not happy with this order. This recalling was allowed. So, in the appeal, my appeal preferred against this order failed on the ground because the petitioner had withdrawn the writ and main order has already been set aside by the coordinate bench. sorry, it is recalled by the coordinate bench upon an application by other side, writ petitioner, there is nothing to be decided in the appeal because the single judge bench itself after disposal upon their application recalled that order. Therefore, there was
recalled for the reason that executive engineer will not consider it will be by the project.
I am coming to the order itself and their application. Their application I have
Where is
annexed.
your appeal order? The appeal order?
My appeal order. I am coming. I am coming.
Show us that appeal order.
Yes.
That has been referred to.
Yes, yes, yes. That has been referred. 10th March 25. That is already order data. That 10th March 25. Paragraph 7. Paragraph 7 and etc. I'm paragraph 7, page 169. I'm sorry, page 169. 169. This is the order passed in my appeal preferred against the main order, which records
page 169.
169, annexure P5 of stay application. First paragraph itself, your lordship will find the intra-court appeal has been filed challenging order dated 7th February 24 in WP number 2018. The impugned order was subsequently recalled at the instance of writ petitioners. Did your lordship get it? The impugned order was subsequently recalled at the instance of writ petitioner who filed can number 1 and can 2, and the direction was modified. The appellants are aggrieved now by modified order dated 12 July 24, which has not been assailed in memo of appeal. Therefore, the appellant seeks to withdraw the appeal and file a fresh appeal questioning correctness of modified order. Pursuant to that, my lord, this appeal was filed.
Which appeal?
The present one before your lordship. Present one is mat number 475 of 25. The present appeal is filed after this 10th March 25 order. The present, because my lord, by that time the parent order was recalled. It is only the modified order which was holding the field. Therefore, while the
against that order 7th February you have come.
No, I have, my lord, come against modified order.
Modified.
Modified order.
Very good.
My lord, am I clear, my lord? Now, my lord, two applications.
No, what is your ground of?
Now, my lord, I am coming to the ground straight away. Because
now the project officer has implementation has passed
the project director, pursuant to modified order, called for hearing to my clients. There were 3-4 order dates on which hearing were called. On 2 dates, it is recorded in the order I can place, my lord. I will come to that. In 2 dates, adjournment was simply allowed because of pendency of appeal. On 3rd date, we, according to our client, did not receive any communication that it has been deferred to 6th March 25. That was the last date of hearing in pursuance of modified order, which is to be passed order by the project director, which is to be carried out in pursuance of modified order. That is 12 July. Now, my lord, here I, my lord, make my point. If the project director, even though acting upon a modified order, do not communicate my client about the date when it is fixed, that is 6th March 24, the principle underlying order 9 rule 13, that the same was not notified to my client and the order was passed in absence, gets attracted. Your lordship, my lord, are aware of the judgments since 2000 Supreme Court. That
very good. Show us that 6th March order have you annexed?
My lord, I have annexed, but before I take your lordship, my lord, 6th March,
page 171 of the stay application.
I submit that, my lord, I submit that 6 March, apart from 6 March order, the order which is assailed before your lordship is a modified order. I submit, my lord, that the writ court could not have entertained these two applications post disposal of writ petition. Why I submit, my lord, that the application made by the writ petitioner.
How you have been prejudiced?
I come to that.
How you have been prejudiced?
I submit, my lord.
There was a direction previously that if any further thing happens, make a
The
representation.
lordship is absolutely correct. Now,
So don't argue that point. Now you show us that no here opportunity was given to you.
it is recorded in the order itself. Kindly come to page 171. But, my lord, I am kindly, since it is falling from your lordship, kindly have a look to this. But I am on another point of law. Your lordship is going to the order by taking into consideration that if the modified order is accepted, what post modified order has happened. Kindly come to page 171 because it is falling from your lordship. It records none of the private respondent have appeared.
Where is that? Where is?
Page 171 of the stay application.
No private respondent hearing held on 20th February.
Today, no private, 1, 2, 3, 4, 5th, 6th, 7th paragraph. Today, no private respondent, 6, 7, 8, 9, 10, and 11 have appeared for hearing on 6/3/25. Thereafter, it continues and the order has been passed.
Well, kindly consider paragraph number 5.
Yes,
however,
kindly come to
however, on the
paragraph
basis
5.
of the presence of the private
Yes.
respondent number 6, 7, 8.
Yes, kindly
the name
come
of
to,
the appellants through their advocates Pompra Mujumdar.
kindly come to,
And they filed an application for adjournment.
You will get your chance.
kindly come to paragraph 5, which my learned friend was insisting upon. However, kindly may not take trouble to that. However, on the basis of private respondent, Prabhas Buddho Ganesh through their advocate Pompa Mojumdar, vide letter dated 27/1/25, request for deferring date of hearing scheduled to be held on 28/1/25 and next date of hearing is fixed on 22/25. This pertains to fixing of a date on February 2025. Therefore, it doesn't pertain to fixing of date on 6th March 25. So far as 6th March 25 is concerned, I have, my lord, the entire bunches because I asked my client to bring the entire.
In front of you, the date was scheduled.
No, it was shifted.
On medical ground, next date is on 20th.
It was shifted with
on
regard.
20th, you did not appear.
On 20th, your lordship is absolutely correct.
Very good.
My client engaged a lawyer on that date.
On 20th February, nobody was present.
20th February,
Nobody was present.
Nobody was present, but the date was not fixed on 6th March on 20th February.
Yes.
Thereafter, 2 dates were further fixed. When, because
considering the repeated absence, final opportunity is granted.
the order, the final order which is being passed.
After 20th February, what
2 dates were fixed.
Tell us which dates.
বলছি একটুখানি ডেটটা নোটিশ দেখে বলো, নোটিশটা দেখে 20 ফেব্রুয়ারি পরে না বুঝতে পারছো না, ওই নোটিশ গুলো যেগুলো দিয়েছেন না ওর মধ্যে কাইন্ডলি অ্যালাউ মি 1 মিনিট। যে নোটিশ গুলো বুদ্ধ ঘোষণা দিয়েছিলেন ওর দুটো দিন কবে ফিক্সড হয়েছিল, কাইন্ডলি অ্যালাউ মি 2 মিনিট। নোটিশ গুলো কবে ফিক্স করেছিল
ও বলছে এই 20th আর 6 দিনের মধ্যে দুটো।
Kindly allow me 2 minutes, I will give that, my lord, because all the
also us because the order does not reflect so.
No, your lordship is absolutely correct that the order does.
Paragraph my brother points out on the basis of direction matter was heard on 1, 2, 3, 4, 5, 6, 7 occasions.
7 occasions.
In your contention is in between 20/25 and 6/3/2020.
There were
2 other days. Is it so?
Yes.
Eh?
Yes.
What happened on those days?
The first point which I raised, that let the respondent, including the writ petitioner also.
Well,
My
they
learned
have-
friend-
they have
এক
chosen-
second, I'm
Or
the writ petitioner is
show
here.
us 2 dates.
And
If you
notice
don't
that
appear
also
after
date টা চাইছেন রে বাবা।
after fixation of a date, Mr. If you do not appear, how can you insist that a further notice has to be given?
My lord, why I say that writ petitioner, how he came to learn that 6th March is fixed?
Because he went to the office.
May I just clarify? It's the authority on each.
You're trying your best, but
No,
you
no,
are
no.
a bad case.
My lord, it's not trying. I take a specific point that no notice was issued by this
Not
respondent.
required.
No, I say.
You are my hearing officer. I go to you, say, sir, I am sick today, fix another day. You fix another day.
But in this case,
show us that in between 22-25 and 6-3-25, there were 2 other days.
এটা নয়, যেটা অথরিটি আমাদেরকে বুঝতে পারছো না। সরি মিলন, অথরিটি যেগুলো আমাদেরকে ডেট গুলো কমিউনিকেট করতো ওটা জিজ্ঞেস করছি। যে
Not required.
Not required, but my lord, after
You are for whom?
I am for the state.
I am leading Mr. Raja Datta.
You are for project director.
Yes, I am led by Mr. Datta, my lord.
I'm
Are there any 2 dates in between 20th February and 6th March?
No, 6th March fixed on their request.
No, he's saying in between 20th February, to 6th March, there were 2 other dates. Is it so?
Yes, so you ordered us to 171.
My lord, I understand, my lord, subject to what my learned.
Let us ascertain.
They appeared on those 2 days.
These notices were
We have
issued to
appeared.
writ petitioner also.
Kindly come.
So when the writ petitioner is entitled to a notice that on 6th March it would be heard, and all notices were issued to all parties, my client also is entitled to that.
Sir, you did not appear on 20th March, 20th February, you made a prayer. 28th January, you made a prayer. That adjourned today.
Yes, medical.
You adjourned to 20th.
Yes.
On 20th, you did not appear. Had you appeared on 20th,
My lord,
you would have
what,
come to learn.
my lord, I will just clarify, my lord, what is falling from your lordship. On 20th, the hearing did not took place. They said that we will communicate you the date. Thereafter, the authority issued notices.
Sir, you were not there on 20th. How do you know this story?
Because your lordship is absolutely correct. How I learn about this? Because after 20th, this authority issued us notices fixing one date.
Show us that why you are so unnecessarily troubling
No, your
yourself.
lordship is absolute.
সাতকান্ডু রামায়ণ পাঠ
খামটা
করে
দাও,
শিখে।
এনভেলাপের খামটা বলছি, এনভেলাপের খামটা বলছি যেটা kindly excuse me, my lord. বলছি,
You have not got it.
my lord, kindly, my lord, I have those notices, but kindly allow me 1 day's time.
Can you show us
I will
the
bring those
notice
notices, my lord.
which was
Yes.
given to
I
you
have
for
a bunch of
20th
notices.
February to 6th March,
Well,
2 dates were
every
fixed.
day, my lord, the
And
date
they
is
are
given by
notice
the
also.
project officer.
I'm sorry. তোমাদের নোটিশটা দাও, তাতেও ক্লিয়ার হয়ে
I
যাবে।
don't have the notice as my lord submitted.
Please show us
Yes.
after 20th February,
Whether there is any
they
notice
did not appear. So you might have fixed another date.
Yes.
His contention is that prior to that next date, you issued fresh notice to the petitioner.
Yes.
But you did not issue notice to him, which does not appear to be believable at this stage.
Lordship,
I will file affidavit.
No.
not required, my lord.
But let
Come up
them
with
show
this
this, my lord.
specific instruction whether there is any notice issued to the petitioner
To
and
anybody.
not the private.
Yes.
Informing hearing would take place on 6th March.
Acha, anything else you said?
No.
Huh?
I'm sorry. Only
Anything else,
informing
Lord?
hearing would take place on March.
His contention is, yes, 20th February, I was not present. But after 20th February, 2 more dates were fixed prior to 6th March. So on those 2 dates, you issued fresh notice. Gap is very simple. 20th February means 8 days and 6 days. So his contention is you issued fresh notices to the other parties, but not to us.
I'll
to
come with
ascertain
that,
that.
only that is.
Yes,
If that is done, very good.
Lordship,
What?
if there is any notice at all,
At all, whether there were two dates or whether any notice was issued, you
I'll
disclose.
come up with a specific instruction.
So when can you come up?
Anytime next week, my lord, any date, my lord. Monday.
Next week, day after tomorrow, we are keeping.
Lordship,
We have heard it. We will finish.
in fact, my lord, I have also already sought for specific instruction on this. The memos have been mentioned in the impugned order, but since due to might be rain and all, my lord, they could not reach, my lord. Day after tomorrow, my lord, I'll be able to.
Let it be taken up day after tomorrow, my lord.
Yes, my lord, I'm late by.
As your lordship.
The day after tomorrow, then.
My lord, one thing, I bow down what has fallen from it. My lord, your lordship has gone post compliance of the order. What has happened? Obviously, that is a factor to be gone into.
Stay on the next
No,
day.
along with only my prayer was, your lordship will consider page 151 and page 158 whether these two applications can be entertained post disposal of writ and these order consolidated by impugned can be passed.
Tenth time you are repeating that subject.
Yes, your lordship will agree.
It's not that we don't
I'm
care.
extremely sorry, Willard. I know that.
No, you must be.
No,
be
I know,
having a
Willard, that.
You might be having a feeling that the honorable judges must sometimes miss off what is being stated.
I'm extremely sorry.
We take whatever you may be having a very bad case.
No,
but it is our responsibility.
It is our
to
fault.
clear
We
it.
sometimes feel that we might be missing that
No,
point.
no, it doesn't
Kindly
miss.
do not take.
We take the learned advocates very seriously. It is not that you will make an argument.
I am grateful to your lordship, but sometimes.
The order determiner, you come on next day after tomorrow.
Day after tomorrow.
So take it away. देखिए आज. এরাও কি বৃষ্টির জন্য আসেনি নাকি? কি করেছে?
এটি অ্যাডজার্নমেন্ট হয়ে যাবে তো
My lord,
বলে দিন যে অ্যাডজার্নমেন্ট হয়ে যাবে
কোনটা? My lord, item 20, my lord.
আরে 18টাকে বলে দিন
18.
18টা অ্যাডজার্নমেন্ট হয়ে
Hearing on behalf of the appellant, I am praying for not this failure due to the fever of the appellant.
Milord, only one submission, Milord. I am very much embarrassed and ashamed to say, Milord, that my clerk has misplaced the brief. Milord, your lordship kindly directs Milord to serve a copy, if required, at my cost. If required, at my cost. And Milord,
She does not know that she.
আমি সব বলে দিচ্ছি তোমাকে। And one.
Who is your senior?
Shantanu Mukherjee advocate.
And one more thing, Milord.
Thursday week.
My lord, one more thing, Milord. From 22nd to 26th, I'll be out of town, Milord. I'll have to go to Bombay with my son. Milord, I'm just praying accommodation for only those 4 days.
We are keeping on 17th.
17th. Grateful. Grateful.
17th.
Item 20, my lord. I am for the petitioner.
Copy দিয়ে দাও।
I have some difficulty at 2 p.m. my lord. So can you make it not today? Item 20.
Not today. Good. Inform your other side. Who is your other
No,
side?
it's a section 19 appeal. My lord, notice this.
New matter. New matter.
May it please your lordships. It's a very short, neat question of law. And I will state the facts briefly. The facts are very brief. And then go to the question of law. Can I hand up a list of dates? It's only 8 or 9 dates. This side. So your lordships know that under the liberalized remittance scheme, a person can remit money abroad for certain specified purposes. The facts are not in dispute. The petitioner remitted money to a bank in Singapore for the purpose of trading in securities in the Singapore market. He also took short-term advances from that bank to further enhance his capital for securities transactions. The transactions were closed in 2015. It started in 2011 to 15. The account was closed. The entire money was remitted back to India. The principal amount which was remitted, as well as the gains from the transactions, were all remitted to India. Between February 2011 and September 2015, and there are no disputes about the transactions. Nobody has found fault with the transactions, except that for the borrowing from the Singapore bank, petitioner had not taken the prior permission of the Reserve Bank of India. That's the only allegation. It's a finding is it's non-criminal. It's a regulatory violation on the ground that you did not take the prior permission of the Reserve Bank of India. Well, these are stated in paragraph 4 to 10 of the affidavit, is it? 4 to 10 of the petition in the memorandum of appeal. I'm not reading that. That sums up what I told your lordships in a couple of minutes. Those paragraphs describe the transactions. 7 years later, just kindly see the list of dates. I'll run through them. The transactions were closed in 2015. In November 2022, a show cause notice was issued by the Special Director, ED, alleging various violations. I filed a compounding application on 21/23. It was returned saying there were some defects there. You are given liberty to file a fresh compounding application. So I did file a compounding application immediately after the show cause notice on legal advice, but it was returned by saying there are some defects. You please provide the information and liberty to file a fresh one. On return, my advice was, my legal advice, which I'll make good. The petitioner's legal advice was, you can wait until the adjudication of the matter is done. And I'll tell you, lordships, why. Under the scheme of the Act, without an adjudication, you can't know which is the compounding authority. I'll show the provisions. Adjudication order was passed by the Special Director on all the issues. Kindly note, my lord, that Section 3A, which was alleged in the show cause notice, exonerated. Section 3B exonerated. Only Section 4 is found, namely that I did not take the prior permission of the Reserve Bank of India. All other offenses alleged in the show cause notice have been cleared. So the only offense is Section 4. After the adjudication order is passed on 28/3/24 for adjudicating a penalty of 10 crore, I file, again on legal advice, a fresh compounding application to the RBI. I'll tell your lordship why to the RBI. Under this act, peculiarly, there are two compounding authorities. In respective offense under Section 3A. 3A, it's the ED. It's the Enforcement Directorate. 3A is the Enforcement Directorate. All other offenses is the RBI. An interesting conclusion arrives, according to me, that without knowing which is the offense, how do you file a compounding application? There is also a riddle, my lord, unsolved riddle. Suppose they find 3A and another provision. Who is the compounding authority? I have not been able to find an answer, but that doesn't arise in this facts of this case. If it is 3A, the compounding authority is the ED. If it is all other sections, the compounding authority is the RBI. In this case, the adjudicating authority found me guilty of violating Section 4, and then the RBI becomes the sole compounding authority. I file a fresh compounding application on 10/5. On 11/9, the fresh compounding application is rejected by the RBI and returned on the sole ground it's not maintainable by stating that the compounding cannot be done once adjudication order is passed. That's the question of law. Can a compounding under the Act and the regulations and the RBI's instructions, can a compounding application can be maintained after an adjudication order? That's the only question, and I'm sure your lordships will resolve that. I filed a writ petition. I filed writ petition 30/030. In the meanwhile, a few days later, the demand notice for 10 crore was issued. Therefore, I filed an amended writ petition. I filed a fresh writ petition challenging the 10 crore adjudication order as well as the demand. Then WPA 3030 was withdrawn. 3030 was withdrawn and 2065 is on file. And the judgment has been passed by the learned single judge on 1/4, which is why I'm in appeal. These are the facts. My lord, I believe there is no controversy about the facts. Now kindly see the provisions of law. A few provisions of law.
Both the compounding applications were before RBI.
RBI.
The compounding applications were both before the RBI.
The original one was before the RBI, returned with liberty. Second one has been rejected.
In the first writ petition, what did you challenge? Which you withdrew? The first writ petition, you said that
on various grounds, merits, etc., that I'm not guilty, etc., But it was returned on the ground that full information had not been provided, with liberty to file a fresh compounding application.
Liberty was granted.
Liberty was specifically granted by the RBI. My lord, that page, this is page 138 of the stay application. Liberty granted to file a list of dates, the third row, P6, 8/1/24, first compounding application returned, liberty given to file a fresh compounding application. Now kindly see the Act. Well, I've given, for convenience, I've extracted the relevant provisions of the Act regulations, and the compounding rules. Kindly see the Act. Section 3. It's on running page. Have you given the other side? Running page 9. Dealing in foreign exchange. Save as otherwise provided in this Act, rules or regulations made thereunder, or with the general or special permission of the Reserve Bank, no person shall A. Deal in or transfer any foreign exchange or foreign security to any person not being an authorized person. B. Make any payment to or for the credit of any person resident outside India in any manner. I'm not reading the rest because 3A and 3B was alleged and I've been exonerated. 3A and 3B has no finding against me. Now kindly see section 4. Save as otherwise provided in this Act, no person resident in India shall acquire, hold, own, possess, or transfer any foreign exchange, foreign security, or any immovable property situated outside India. The allegation is that when I borrowed short term from the bank, I did not take permission. This is the allegation under section 4. I'm not going to the merits because I'm purely on a question of law. Then kindly see here's a list of section 13. Section 13. 4 I've read. 13. Running page 15. If any person contravenes any provision of this Act or contravenes any rule, regulation, etc., or contravenes any condition subject to which an authorization is issued, he shall, upon adjudication, be liable to pay a penalty up to thrice the sum involved in such contravention, where such amount is quantifiable, or etc., etc. They have quantified it. The rest is not relevant. 4 is the section that I am found to have violated. Now kindly see section 15. Any contravention under section 13, which I read to your lordships, any contravention under section 13 may, on an application made by the person committing such contravention, be compounded within 180 days from the date of receipt of application by the Director of Enforcement or such other officers of the Directorate of Enforcement and officers of the Reserve Bank as may be authorized in this behalf by the central government in such manner as may be prescribed. Where a contravention has been compounded under subsection 1, no proceeding or further proceeding, as the case may be, shall be initiated or continued, as the case may be, against the person committing such contravention. There are 15 creates 2 authorities. One is the Enforcement Directorate, one is the Reserve Bank of India, as may be authorized by the central government. Which is the section which says distinction? 3A. Now, section 16. 16 is appointment of adjudicating authority. We're not concerned with it. Kindly see 17 and 19. there are twin provisions, and I'll see. 17. Appeal to the Special Director appeals. The central government shall, by notification, appoint one or more special directors to hear appeals against the orders of the adjudicating authority under this section, and shall also specify in the said notification the matter and places in relation to which special director appeals may exercise jurisdiction. This is if it is passed by, under subsection 2, an assistant director or a deputy director may prefer an appeal to the special director. Every appeal shall be filed within 45 days, etc., etc. Then is a further appeal to the appellate tribunal under section 18. Now kindly see 19. Save as otherwise provided in subsection 2, the central government or any person aggrieved by an order made by an adjudicating authority, other than those referred to in subsection 1 of section 17, or the special director appeals, may prefer an appeal to the appellate tribunal. If the original order of adjudication is passed by the special director himself, then the first appeal lies to the appellate tribunal. In this case, no? Special director passed. In our case, special director passed the adjudication order, and an appeal will lie to the appellate tribunal. So there are two conclusions I draw and submit with respect is, this act creates two compounding authorities depending upon which provision is violated. One is the Enforcement Directorate, one is the RBI. It also creates two appellate authorities. One, the Special Director Appeals and the Appellate Tribunal. If the impugned order is passed by an assistant director or deputy director, the appeal lies to the special director. If the adjudication order is passed by the special director himself, appeal lies to the appellate tribunal. I don't think there's any controversy about these provisions. Now, my lord, the next set of regulations your lordships may kindly see is item number 2, FEMA borrowing or lending regulations. Starts at page 45. The relevant regulation is at 46. The relevant regulation, and subject to what my learned friend will say from the order, the only relevant regulation is regulation 3. Kindly recall, my lord, section 4 said, save as otherwise provided, no person resident in India shall acquire any foreign exchange and then regulation 3. Save as otherwise provided in the Act, rules and regulations made thereunder, no person resident in India shall borrow or lend in foreign exchange from or to a person resident in or outside India. The allegation is, I borrowed money from a Singapore bank, which is admittedly a resident outside India, and I did not have the Reserve Bank of India, therefore violating section 4 read with regulation 3. That's the only offense, man. Section 4 read with regulation 3. Adjudication has been done only on this violation by the special director, and the appeal does lie to the appellate tribunal. Now, next set of provisions your lordships may kindly see is serial number 3, the compounding rules. These were passed in 2000. These are the rules in force, no?
2024 are in force.
These were in force until 2024. I'll show that. For the period we are concerned, the compounding rules are the 2000 rules. Starts at page 67. Hmm? 4 and 5 also. Now kindly see rule 4. This is important. If any person contravenes any provisions of the Foreign Exchange Management Act, except clause A of section 3, etc., etc., the compounding authorities, assistant general manager, deputy general manager, chief general manager. Kindly see the structure of compounding rule 4. Except in the case of 3A of the Act, all compounding is done by the Reserve Bank of India by one of the appropriate officers. Enter the Enforcement Directorate is only under Rule 5. If any person contravenes provisions of Section 3A of the Foreign Exchange Management Act, the Deputy Director, the Additional Director, Special Director with Deputy Legal Advice, etc., etc., the Enforcement Directorate, only in the case of Section 3A. Where is the show cause notice? No, kindly see the adjudication order of the adjudicating authority, which is dated 28th of March 24. This is in that stay application appeal. Kindly come to page 142. I've given that page in the list of dates. Kindly come to page 142. I will read only one paragraph in 143. Nature of contravention. The third row in the column. Show cause notice, accused show cause notice, nature of contravention. Sections 3A, 3B, and 4. These were alleged against me. I submit, my lord, when I receive the show cause notice, I don't know which is the compounding authority. Because I'm found guilty of 3A, the Enforcement Directorate is a compounding authority. If I'm found guilty of 3B or 4, it is the Reserve Bank of India. Finding? kindly go straight to page 192, what I am found guilty of. 192. Alleged contravention of sections 3A and 3B of the Foreign Exchange Management Act. Those two provisions are extracted. And then at 193, I find that the alleged contravention of section 3A is not sustainable. The next paragraph. Similarly, I also find that alleged contravention of section 3B is not sustainable. After this order, I know that I have been exonerated of 3A. Then next paragraph. Alleged contravention of provisions 4. Section 4 is extracted. Then foot of the page. As regards alleged contravention of provisions of clause 3 of Foreign Exchange Regulations 2000, Regulation 3 I read to your lordship, that is extracted. And the finding is, where is the finding? At page 197, order in exercise of powers conferred on me under section 13(1) of the Foreign Exchange Management Act is the adjudicating authority. Total borrowing of rupees 202 crore at a time, that is 3.94 crore. Maximum amount of borrowing is 3.94. They borrow, I borrow, repay, borrow, repay. They add up the total borrowing and say 202 crore, be that as it may. The maximum borrowing at any one time is 3.96, for which there was no permission from the RBI. Contravention of Regulation 3, and therefore a penalty of 10 crore. That's the only allegation found against me, which I come to know the show cause notice alleged 3 provisions, but I find from the adjudicating authority that I have allegedly contravened, and that is a finding only in respect of section 4 read with regulation 3. Now, my lord, the only question is, can I maintain a compounding application after the adjudication order is passed? My submissions are the following. When I received an adjudication order, I can do one of 3 things. I'm sorry, when I receive a show cause notice, I can do one of 3 things. I can not contest the show cause notice and admit and pay whatever penalty is imposed or whatever. Or I cannot file a compounding application at that time according to proper legal advice because I don't know which is the compounding authority. Therefore, I can await the adjudication order and then decide whether, knowing which is the compounding authority, I can decide whether I should file a compounding or should file an appeal. That is the second course open to me. The third course is the straight course. I can file an appeal against the adjudicating authority's order. These are three courses. I can not contest the show cause notice. I can wait for the adjudicating order in order to know who is the compounding authority and whether I should file, whether it's worth compounding. Or the third course is to file an appeal to the appropriate appellate authority. Because by that time, I don't know who is the compounding authority. When the adjudication order comes, I know who is the compounding authority. Therefore, the choices open to me are, should I compound or should I file an appeal? In order to resolve this dilemma, I believe the RBI issued certain instructions from time to time, which is at serial number 4 of the compilation which I handed up to you, starting at page 73. We have read this rule 11. Now, in the index below to this compilation, your lordship will find it at page 4, serial number 4, starting at page 73.
Mr. Chidambaram, you at that juncture you filed the application for compounding prior to adjudication by the
I did on according to me, wrong legal advice, but on legal advice I filed it, but they returned it with liberty to file a fresh compounding application.
No, we are on the point. If you are saying that you did not know who would be the authority, subject to whether it's an offense under 3A or something else, then how did you file it in the first?
Wrong advice, wrong legal advice. I did not advise my client. Wrong legal advice because he did not know whether 3A or 3B or 4. So how did he file to the RBI? If he had been found guilty of 3A, the RBI was not the compounding authority. It was wrong advice. I have no hesitation in accepting that. It was wrong legal advice. I have a great respect. Some lawyer advised him. But it was wrong because he did not know which is the compounding authority. In fact, my lord, the problem is worse. If you're found guilty of 3A and 3B, who do you compound to? Anyway, that doesn't fortunately arise in this issue. It's either 3A or 4. 3A means compounding authority is the ID. 4 is the RBI. We are saved a major headache, my lord. If 3A and 3B have been found, who do I compound to? Who do I approach for compounding? That doesn't arise.
So when they return it, what did they give any reason? File afresh?
No, I'll show that order. There's no secret about it. At page 138, page 138 of the paper book. 138 of the paper book. It's a short order. Which portion? It's a short order. Dear sir, please refer to the caption compounding application. This is RBI now. This is RBI, my lord. Lordship sees below Reserve Bank of India, Central Office. Please refer. Applicant in his compounding application had mentioned that the portfolio account drew advances on various occasions. However, only the amount pertaining to the peak advance of US dollars 957,000 has been mentioned. Due to the above, there is lack of clarity on the number of advances availed, their respective total amounts, and the dates on which these advances were availed. In view of this, the total amount of advances availed and period of these advances cannot be ascertained, thereby leading to difficulty in ascertaining the amount and a period of contravention. In view of the above, the compounding application of Sri so-and-so is being returned. CEFA division will take care of all other formalities regarding the return of application. The applicant at its option may approach ECBD with a fresh compounding application, duly ensuring that all the clarification information sought above is submitted along with the fresh application.
So is this ECBD?
Exchange control of the banking department.
Just below that.
External commercial borrowing division. External commercial borrowing division. So it was not an order on merits. It simply said you have not furnished all the information which we require. Therefore, we return it. You may, with specifically liberty is given to file a fresh compounding application. Therefore, I submit, my lord, nothing arises out of the first compounding application.
With a fresh compound.
Every borrowing, every repayment over a period of 2-3 years. I had given only the peak borrowing. They are perfectly right, my lord, in asking all the information. And I submit respectfully that they were right in also saying, if you provide the fresh information, you can file a fresh compounding application. But even at that stage, neither the RBI nor I know whether I'll be found guilty of 3A. If 3A has been found against me, the RBI is not the compounding authority. Be that as it may. Now, kindly have this compilation. Please see serial number 3 and 4, one after another, but there is a purpose. Serial number 3 starts at 67. These are the foreign exchange compounding proceedings rules. In exercise of powers conferred by Section 46, read with subsection 1 of Section 15, the central government hereby makes the following rules relating to compounding contraventions under Chapter 4 of the said Act. Namely, these rules may be called the Foreign Exchange Compounding Proceedings Rules 2000. They shall come into force on the first day of June 2000. Rule 3, compounding authority means an officer of the Enforcement Directorate, B, an officer of the Reserve Bank of India. Rule 4 and Rule 5, I read to your lordship. If it is 3A, it is the ED under Rule 5. If it is all other provisions, it's the RBI under Rule 4. Now kindly see Rule 11. No contravention shall be compounded if an appeal has been filed under Section 17 or Section 19 of the Act. Section 17 is an appeal to the Special Director. Section 19 is an appeal to the Appellate Tribunal. depending upon who passed the adjudication order. I read it again, my lord, with your lordship's leave. No contravention shall be compounded if an appeal has been filed. This will be made clear by the instructions, but my inference from the language is, if an appeal has not been filed, you can file a compound. Appeal postulates an adjudication order. Without an adjudication order, you can't file an appeal. Therefore, when Rule 11 says no contravention shall be compounded if an appeal, please read the words, if an appeal against an adjudicating order has been filed under section 17 or 19. If there is an adjudication order and I have filed an appeal under 17 or 19 as the case may be, I can't file a compounding. The converse I submit is correct and true, that once an adjudication order is received and no appeal has been filed, I can file a compounding application. This I submit is made clear by the master direction, which is the next page at 73. My lord, the Reserve Bank of India has issued a master direction consolidating and updating various instructions issued on the various dates from 2016 to 2022. The only relevant paragraphs of these master direction is at page 81. .4. Page 81. In case where adjudication has been done by the Directorate of Enforcement and an appeal has been filed under section 17 or section 19, no contravention can be compounded. In terms of Rule 11, the applicant shall confirm in the undertaking required to be furnished as per Annexure 3, along with the compounding application, that they have not filed an appeal under section 17 or section 19. Reading Rule 11 with paragraph 6.4, I cannot file a compounding application if I have filed an appeal. I submit the converse is true. If I have not filed an appeal, I can file a compounding application. My learned friend's case, as argued before the learned single judges, once an adjudication order is passed, you cannot file a compounding application, which I answer by saying, until an adjudication order is passed, how do I know who is the compounding authority? Number one. Number two, whether the adjudication of a penalty is a small amount, I might as well pay it. I won't file an appeal, I won't file a compounding. The more important question is, without an adjudication order, on a show cause notice which alleges both 3 and 4 of the Act, how do I know who is the compounding authority? In this case, that situation is real. The show cause notice alleged 3A, 3B, and 4. Unless I know the adjudication, I don't know who is the compounding authority. And then Rule 11 And the master direction, paragraph 6.4, makes it clear. After an adjudication order is passed, you can file an appeal under 17 or 19, depending upon the adjudicating authority. But if you file an appeal, no compounding. So the converse, if you don't file an appeal, you have a chance to compound. That's the only question, my lord. The question which your lordships may kindly consider and decide is, after an adjudication order is passed, before an appeal is filed, can you make a compounding application? We are joined on that issue. According to me, I can if I don't file an appeal. He says whether you file an appeal or not, after an adjudication order is passed, no compounding, which means Rule 11, paragraph 6.4 is meaningless, becomes completely ocious. Now, my lord, there are two minor points. That's the legal submission I've made. Two minor points. Serial number 5, another circular was issued on 1/2/2005, starting at page 89 at 98. It starts at 97 and 98, compounding process, which was relied upon by my learned friend. Paragraph 6, application for compounding any contravention may be filed with the compounding authority, including those which are under adjudication process and have not been disposed of. No contravention would be compounded which has been finally adjudicated and disposed of by the adjudicating authority.
You're reading page 97.
Page 97, it starts at 98, paragraph 6.
Paragraph 6.
Application for compounding any contravention may be filed with the compounding authority, including those which are under adjudication process and have not been disposed of. No contravention would be compounded which has been finally adjudicated and disposed of by the adjudicating authority. This squarely supports him. This was issued on 1/2/2005, but it has since been superseded at page 99. Kindly remember the date, my lord, 1/2/2005. Kindly read paragraph 2. The compounding of the contravention under FEMA was implemented by the Reserve Bank by putting in place the simplified procedures with effect from 1/2/2005, with a view to providing comfort to the citizens and corporate community by minimizing transaction costs, while taking a serious view of the willful malafide and fraudulent transactions. It has been decided to put in place an updated procedure for compounding of contraventions under FEMA on the basis of observations made over the last few years on the compounding process on a continuous basis and the experience gained. The objective is rationalization and streamlining of the process and the procedure for compounding, and to enhance transparency and effect smooth implementation. The directions contained in the compounding of contravention issued under circular number 31 are superseded by this circular. This had a life, therefore, only between 2015 and 2005 to 2010. it no longer available after 2010. Our adjudication order, impugned adjudication order, is passed in 2024 when this circular was not available. I'm just putting it out of the way. If reliance is placed on 1/2/2005 in support of the RBI's case, that has been RBI itself has superseded it in 2010. That's no relevance. The second matter, which my learned friend, I had on day relied on 24 rules. To complete the facts, the new compounding rules has been passed on 2024. It is serial number 7 at page 106. According to me, it is in my favor. 2024 rules superseded the 2000 rules. In exercise of powers conferred by Clause B, etc., and in supersession of the Foreign Exchange Compounding Rules 2000, which is at serial number 3, except as respects things done or omitted to be done before such supersession, the central government hereby makes the following rules. So it saves all past actions. It supersedes prospectively on 12th September 24. Your Lordship may kindly note the date, 12th September 24. And my learned friend naturally relied upon Rule 9 of the new rules. Rule 9 is at page 109. No contravention shall be compounded. A, B, C. Now kindly come to D. Where the adjudicating authority has already passed an order imposing a penalty under Section 30. He relied upon this. Correctly, if these were the rules applicable, after these rules come into force on 2024, you can't file a compounding after an adjudicating order is passed, irrespective of the dilemma, who is the compounding authority. Anyway, that will arise in a future case where 9D will have to be interpreted by your lordships. Be that as it may. But kindly see the Rule 14, which I great respect. He doesn't advert to. Any compounding application pending before the compounding authority on the date of commencement of these rules shall be governed by the provisions of the 2000 rules superseded herein. So if an application for compounding is pending on before 12/9/24, old rules will govern, and my compounding application was filed on 10/5/24 and returned as not maintainable on 11/9/24, serial number P8 and P9. So it was well before 12 September 24. It is well before 12/9/24. It was pending and disposed of before 12/9. It was pending from 10/5/24 and it was disposed of on the previous day, 11/9/24. These new rules come into force only on 12/9/24. Therefore, the new rules don't apply. The old rules apply. I think they were waiting for the 11-9 compounding application to return before they made the new rules, fella. Whatever. Therefore, the new rules of 2024 have no relevance to our case. It is the rules of 2000. The rules of 2000 make it clear in my submission, Rule 11 at page 70, read with paragraph 6.4 of the master direction at page 81, make it absolutely clear that after an adjudication order is passed, if I do not file an appeal, I can maintain a compounding application. The only ground on which the present compounding application has been returned is P9 at page 165, and I close my submissions at page 165. I'm sorry, I've given the wrong page. Hmm?
223, sir.
This is wrong.
It's wrongly mentioned as 163.
My lord, in the list of dates is mentioned as 165 on the second page. Kindly pardon me and correct it to 223. 165 is wrong. The list of dates I gave, 165 is wrong. The application was at page 199. The disposal is at 223. How did it creep in? Sorry, I'm sorry, Miller. 223. It's not 165. Please correct it. Huh?
12th of September.
How did that mistake creep in? All right, so 223.
Implausible will abide by the rules of
There's impugned order of the RBI. This is one paragraph. In this connection,
203.
223. I apologize for the error. Please correct your list of dates, my lord, otherwise it will create confusion. Please refer to your application dated 10th May. Received in the Reserve Bank on 13th May, seeking compounding. In this connection, since the adjudication order has already been passed by the adjudicating authority with respect to contraventions applied for you in compounding application, your compounding application cannot be processed. Therefore, the caption compounding application is returned. Only ground, not on merits. There is a prayer in the writ petition. Prayer. Your copy, you can't tell me. Prayer in the writ petition, my lord, is at page, paper book, page 101. Paragraph 35. Prayer is foot of the page. A writ order, a direction, certiorari, quashing the impugned order dated 11/9/24. That is at page 223. Then mandamus directing R1 to hear and dispose of the petitioner's compounding application dated 10/5. Rule nisi, injunction restraining the adjudicating authority from enforcing the demand for 10 crore. The legal submission is once an adjudication order is passed. If I have not filed an appeal either under 17 or 19, I'm entitled to file a compounding application. All the more for the reason that only after the adjudication order is passed, I will know whether the compounding authority is the RBI or the ED. In this case, I knew that 3A, I have been exonerated. 4, I have been found guilty. The compounding authority is admittedly the RBI. Therefore, I was entitled to file an application to the RBI under Rule 11, read with of the compounding rules, and read with paragraph 6.4 of the master direction. And that compounding application ought to have been disposed of on merits by the RBI. Those are the submissions. Now, just take 5 minutes to look at the order appealed against of the learned single judge. Learned single judge has given, if I may say with respect, the learned single judge's own view of compounding without adverting to the rules and the directions. The learned single judge has noted my argument at paragraph 14. The order starts at 234. Paragraph 13 notes the provision. Rule 11 of the compounding proceedings rules stipulates that no contravention shall be compounded if an appeal has been filed. Then paragraph 14. The petitioner interprets Rule 11 by submitting that the compounding will not be permissible if and only if an appeal has been filed, as the petitioner has not preferred the appeal but has accepted the order of the adjudicating authority. Accordingly, permission ought to be given to the petitioner to seek compounding of the contravention. She refers to the master direction. She refers to paragraph 6.9 at paragraph 19. Direction 6.4 mentions that in any case where an adjudication has been done by the Director of Enforcement and an appeal has been filed, no contravention can be compounded and shall give an undertaking. Now she relies upon the superseded direction, paragraph 21. Clause 6 of the compounding process dated 1/2/2005, which has been superseded, lays down that application for compounding contravention may be filed with the compounding authority, including those which are under adjudication, have not been disposed of. No contravention will be compounded which has been finally adjudicated and disposed of. Then, my lord, she doesn't deal with, the learned judge doesn't deal with this rival contentions. If I may say with respect, from paragraph 23 onwards is a learned judge's own views on what is compounding. It's not based on any rule or direction. Kindly see paragraph 23. Compounding cannot be claimed as a matter of right, but it is always subject to the legal provisions. Once the offender, contravener, agrees to avail the benefit of compounding, the same implies that the party is agreeable for a settlement and there is no requirement of the issue being taken up for adjudication. The next sentence is neither borne by the act or the rules. The very object of compounding an offense will be frustrated if prayer for compounding is made after the adjudication process is concluded. Well, that is the learned judge's own view. If she has reached the conclusion at paragraph 23, there's no further discussion. This is not based on any rule or provision. Now kindly see paragraph 25. The learned senior counsel petitioner submits as legal advice. The petitioner did not file any further application for compounding. Adjudicating authority proceeded with adjudication and passed final order imposing penalty. After the adjudication order was passed, application for compounding was filed by the petitioner. Then that is set out. Then 28. In the instant case, the offense of the petitioner was a compoundable one. Then paragraph 29 is, with the great respect, my lord, no, completely unjustified. It appears that the petitioner simply tried to test the waters and to see as to whether the adjudication order comes in his favor or not. I'm entitled to wait for the adjudication order. I may be exonerated of all charges. After the adjudication order went against him and penalty amount has been quantified, the petitioner seeks to proceed with the compounding. Had the petitioner been aggrieved, he would have been required to prefer an appeal, and for doing so, the petitioner to deposit the entire amount of penalty. The petitioner is trying his level best not to pay the penalty that has been imposed and delay the proceedings for an indefinite period. Where is the justification for all these comments, Miller? Observations. The moment the adjudication order is received by me on legal advice, I'm told you can file a compounding now without filing an appeal. I didn't file an appeal, I filed the compounding straight away. Then paragraph 30. So fourth line. The contravention which took place in the years 2011 to 2013 was detected by the authority and show cause notice was issued in the year 2022. After the offense of the petitioner has been adjudicated and penalty imposed, the petitioner would be bound to pay. No justification. Permitting the contravenor to avail the benefit of compounding at this stage would require the entire issue to be reopened all over again. The same will frustrate the whole adjudication process. Compounding is to set up not an adjudication order, because there is a table, they calculate, and if I don't file an appeal, they will compound. That is the rule. Entire time period consumed in the process of adjudication gets wasted. Then para 32. The order which is executable at present is the order of the adjudicating authority. Not more than one order of the same set of facts can be permitted to be executed is one of the cardinal principles of jurisprudence. I don't know, my lord, any such cardinal principle of jurisdiction. If the prayer of the petitioner for compounding after conclusion of the adjudication, there will be two orders. First, the order of the adjudicating authority, and second, the order of the compounding authority. There is no conflict. After adjudication, do I want to pay the penalty, or do I want to appeal, or do I want to compound? The compounding authority does not have the determination of the jurisdiction to cancel, overrule, or set at naught the adjudicating authority. There's only one order that survives, and that is the order of the adjudicating authority. Then, 2 lines below. The petitioner could have pressed the application for compounding any time prior to the conclusion of adjudication. That is the issue the learned judge was asked to decide. Then last line. After the adjudication is complete, an offense has been established, the contravenor would be bound to comply with the direction passed by the adjudicating authority. Then 34, she puts the onus on me. The act is in place since 1999. The petitioner has not been able to show a single instance when the authority permitted compounding after conclusion. The question is whether the act and the rules allow it or not. As a said situation is not contemplated, there is no time limit prescribed within which an application for compounding can be filed, etc. It will be open-ending process. Send a last 4 lines, send a very wrong message to the society. My lord, she does not rely upon, the learned judge does not rely upon, with greatest respect, any section or rule or direction against me. The learned judges refer to the provisions, but she does not take it to a logical conclusion and say, because of this section, because of this rule, because of this paragraph, I'm holding against the petitioner. There's no reasoning at all. This is her view, learned judge's view of what should compounding be. If adjudication takes place, no compounding can take place. This is paragraph 23. After that, there's no reason to write any further judgment, because if she a priori comes to that conclusion, a priori comes to the conclusion that after adjudication, no compounding, then there's no reason to write a judgment or refer to any section or rule. Based on the law, the section what? Section 15, compounding, rule 11, read with paragraph 6.4 of the direction, I'm entitled to file a compounding application after the adjudication order. My learned friend is positioned to the contrary. Your lordships will decide the question. I'm deeply obliged, my lord.
Thank you. Anything else you want to say?
No. My lord, just one minor point. Before rejecting the compounding application, I was not heard by the RBI. Just a point. Because if I had been heard, I would have explained what I've submitted to your lordship. I would have explained to the RBI. And maybe this maybe the RBI would have been satisfied. Page. This is at page in the paper book, in the compilation at page 70. 70. This is the direction, is it? This is the rules itself, 2000 rules. Rule 8.2, procedure for compounding, at page 69 of the compilation. I'm sorry. The compounding authority may call for any information. The compounding authority shall pass an order of compounding after and affording an opportunity of being heard to all the concerned as expeditiously as possible. Therefore, if the RBI had heard me, whether the application for compounding is maintainable or not after adjudication, I could have maybe persuaded the RBI that under Rule 11, read with paragraph 6.4 of the RBI's direction, I am entitled to file a compounding application after adjudication and before an appeal. That opportunity was not given. Your lordship saw that. It simply returned it saying not maintained. Those are the two grounds, legal grounds, and one is the opportunity, principles of natural justice, as well as the sub-rule is violated. Deeply obliged, madam.
Such. May it please your lordship, my lord. What I wish to do, my lord, is to show your lordship how these sections lead inevitably to the conclusions which the learned single judge has come to, and that the learned single judge, my lord, has in fact narrated all those sections in before coming to the conclusions. So what my learned friend, my lord, appears to have done in his opening is to say that look at the conclusion, there is no reason given there, so therefore there is no reason, it is just an ipse dixit. In my respectful submission, what the learned single judge did was to look at the provisions and then come to the conclusion. When she is giving her conclusion, naturally, my lord, it is a final conclusion. But before I go to that, my lord, my learned friend's first and primary argument is that prior to the adjudication being completed, it is not possible for him to go for compounding.
Yes.
That's the primary argument, my lord. My lord, this argument, my lord,
yes.
my lord, this argument, my lord, is contrary to the sections itself, my lord. I'll show you, lordship. Your lordship had put the question that you yourself took out the first application for compounding before the adjudication was over. How did you do that? My learned friend's reply today is that it was a mistake. I respectfully submit, my lord, that was never his case, that he was mistaken, and correctly so, because before I do anything else, my lord, please have a look at section 15, subsection 2. Keeping in mind, my lord, that my learned friend's contention is that till the adjudication process is over, it is not possible to go for compounding. First of all, my lord, look at section 15. Power to compound contravention. This is at page 18 of the compilation that my learned friend has handed up. Power to compound any contravention under section 13 may, on an application made by the person committing such contravention, be compounded within 180 days from the date of receipt of application by the Director of Enforcement or such other officers of the Directorate of Enforcement and officers of the Reserve Bank as may be authorized in this behalf by the central government in such manner as may be prescribed. I will come to, my lord, the relevance of the timelines later on. But look at 2. Where a contravention has been compounded under subsection 1, no proceeding or further proceeding, as the case may be, shall be initiated or continued, as the case may be, against the person committing such contravention under that section in respect of the contravention so compounded. So, my lord, clearly envisaging that it is something which happens either before the initiation of process or during the pendency of the process of adjudication. I place that again, my lord. Where a contravention has been compounded under subsection 1, no proceeding, because, my lord, he can compound even before adjudication happens. He is given the right to compound as soon as, my lord, he is notified, show cause notice is given to him. No proceedings or further proceedings, as the case may be, shall be initiated or continued, as the case may be, against the person. So therefore, my lord, during the pendency of the adjudication process, the matter can be compounded, and if it is compounded, then the proceedings ends there. And I will show you, lordship, my lord, where that is also made clear in the rules. Now, so as not to leave this point hanging only on, my lord, a reading of the sections, the question is, there are certainly 2 different authorities, to whom you can approach for compounding. My learned friend's substantive argument is, how do I know who to go to till the adjudication is complete? Now, my lord, what is compounding? Compounding is you accept and go for a decision on how much is to be paid. Now, you are told that you are accused of 1, 2, 3. It is for you to decide which one you wish to compound and which one you do not wish to compound, because you are satisfied that you have a good defense. So, 3A, 3B, and 4 are in his show cause notice, in his show cause memorandum. He can decide that he wishes to compound 3A and not 3B and 4. He can decide whether he will compound all 3, or he can decide whether not to compound only 4 and not 3A and 3B, because he knows that he has taken legal advice and he knows that 3A and 3B has not been made out against him. Well, this idea that you need an adjudication to compound is fundamentally flawed, my lord. Kindly consider when compounding takes place in the normal course in a court of law. In fact, my lord, when you compound, you have to accept that yes, there has been a contravention. That is directly contrary to going for adjudication, where you say, no, I have not committed it. So, my lord, the basic argument which my learned friend has put forward, that I cannot possibly go for compounding, is wrong. I cannot go for compounding before adjudication is over. That is wrong. It is wrong because that's contrary to his own conduct. It is wrong because it is contrary to section 15(2). It is wrong because it is perfectly possible for him to go for compounding. Compounding is done at a stage when the court has not finished its adjudication. And if it is allowed, if he is allowed to go for compounding only because he has lost in the adjudication, that is when the learned single judge says, you have taken a chance, and then after that compounding is not possible. And my lord, just to clinch that point, my lord, and I'll go through all the sections one by one. Just to clinch it, my lord. Section 14, which my learned friend has not relied upon or placed, shows that once the adjudication process is completed, except for it being set aside on appeal, the penalty has to be deposited within a particular time frame. So therefore, if you go for compounding after adjudication, what happens to the adjudication order? The compounding authority cannot deal with the adjudication order at all, because section 14 says that only subject to appeal he has to pay. Please see section 14 because that is very critical.
EA 3B 4.
4.
Compounding is acceptance. Now, suppose he feels
yes,
that I have enough material
yes,
for all the 3.
Then don't go.
Then does he, if that is his guess that I might ultimately win, I must ultimately come to a conclusion as regards.
Yes, correct, my lord. Now, that is the very decision that a person has to take when he decides whether to compound or not to compound. The compounding never happens once you know that you have been convicted. The compounding always happens when you do not know whether you will be convicted or not, but you know the materials that you have, you know what you have done, and you then say that on the basis of this, I'm satisfied I'll be able to defend myself, or that I don't want to take that risk, I will go for compounding.
But if he says that I'm satisfied only about 3B, then does he file 2 applications before
No.
2 authorities?
Only about 3B.
Only?
Yes.
Suppose, sorry.
Only about 3B, yes.
3A, 3B and 4.
4, yes, my lord.
I feel that 3B I won't be able to substantiate.
Very good, my lord.
So against that I will apply for compounding.
Correct.
And 4 also I cannot substantiate. So for 4 I will go for compounding.
Yes, fine, my lord.
And leave aside 3A.
Leave it aside.
So then we is it to be addressed to 2 compounding authorities?
My lord, there is a possibility.
If it is 3A and 4,
yes, correct, correct.
Then
Correct.
it has to be 2 compounding.
It could be. It has to be, because my lord, consider the other option. Suppose we go for an adjudication. Suppose he is found liable under 3A and 4. Then according to him, he can go for compounding. He'll have to go to 2 authorities.
Now, is there any such provision in the statute that in this sort of a dilemma, this
Yes.
has to be done?
Yes, yes. No, my lord. Let me indicate what I'm trying to say. 3A goes to the enforcement directorate.
Right.
3B and D, subject to correction.
3A and 4 to the action.
Huh? Right. So therefore, let us go back, my lord, to rule 4 and 5 for a minute,
Yes.
because that shows who will have to compound for which. We are coming to, my lord, the compounding rules.
Page 67, I think.
60, no, wait. 67 at 68. Gives the 2 different situations, 4 and 5. It is not in the statute, my lord. The statute says as prescribed.
Yes,
Section 15(1) says as prescribed. So, my lord, that takes us to the rules. Now, when is RBI to compound? 4 says, if any person contravenes any provision of the Foreign Exchange Act except 3A. So 4, if there is 3B and 4, it has to go to RBI. And then kindly see 5. The power of the enforcement directorate to compound, if a person contravenes provisions of 3A, then enforcement directorate. One minute. Against him, 3A, 3B, 4. If he is found to have contravened 3A and 4,
then 2 applications.
There will be 2 authorities to which he'll have to go for compounding even by his argument. So that is not a problem. I'm not saying that that's a problem. I'm saying your lordship is putting to me, Lord, what will happen in such a situation?
Yes.
Will he have to go for 2 different compounding? Answer is yes, even on his argument. Because suppose he is held liable under 3A and 4, the authorities for compounding are separate, so he will have to go to 2 separate authorities after the adjudication, as he says. Now consider what I'm saying. You have to go before adjudication. You might have to go to 2 different authorities. It depends on your assessment. It depends on your assessment.
So you're saying not knowing which contravention I'm accused of or
Yes,
charged of,
yes.
I don't know the authority, that will not hold good even if he goes for a compounding.
Correct.
He'll have
Because he knows what he is accused of.
Correct.
The show cause tells him what he is accused of. It is for him to decide based on what he knows about his conduct to apply for compounding of one or more of them. It's his choice. It is not correct to say that he has to wait for the adjudication. That's the section after all. We are looking at the rule. We have looked at the rule. Now see the section again. Section 15, page 18. Any contravention under 13 may, on an application made by the person committing such contravention. So he thinks he has contravened. He goes for compounding. He thinks I have not contravened. I'll wait for the adjudication. I have enough material. Be compounded within 180 days from the date of receipt of application by the Director of Enforcement or such other officer of the Directorate of Enforcement and officers of the Reserve Bank as may be authorized on this behalf by the central government in such a manner as may be prescribed. The prescription is the rule. Full Milord right has been given to him to apply for contravention of one or more of the allegations against him. And section 15(2) puts paid to the argument that contravention, compounding can only be done after adjudication is over. Because it says that it will happen. When it happens, no proceeding or further proceedings will be initiated or continued against the person. And in fact, my lord, there is a rule which says that it will be intimated to the authority and then it will come to an end. Let me give that also, my lord, to complete this picture. Kindly come to page 69. Rule 6. Rule 6 and 7. Page 69.
Yes.
Now, my lord, after this, there will be no doubt in your lordship's mind, my lord, I respectfully submit, that it can be done before the adjudication. Where any contravention, page 69, rule 6, where any contravention is compounded before the adjudication of any contravention under section 16. No inquiry shall be held for adjudication of such contravention in relation to such contravention against the person in relation to whom the contravention is so compounded. So if he has gone for compounding 3A and it has been compounded before adjudication, the inquiry shall stop. No inquiry shall be held for adjudication. It will stop. That's the end of the proceedings. Now, in the face of Rule 6, my lord, it can never be said that I can't go till the adjudication is over.
So, till such in relation to such contravention.
Correct. Correct, my lord.
Suppose it is 3A, he
Yes.
goes to the ED.
Yes.
And if it is compounded, his
Then
proceeding so far as 3A,
3A will end there. The adjudication will go on before RBI for 3B and 4. Before the adjudicating authority, sorry, not RBI. RBI is the compounding authority. So if it is 3B, so he compounds 3A. He knows that there is a problem with 3A. He compounds it. Immediately that inquiry will stop. No further adjudication. And it is before the adjudication. Now 7 also. 7. Where the compounding of any contravention is made after making of a complaint under subsection 3 of section 16, such compounding shall be brought by the authority specified in Rule 4 or Rule 5. Those are the two rules your lordship saw. Either RBI or the Enforcement Directorate. It shall be brought by the authority specified in Rule 4 and Rule 5 in writing to the notice of the adjudicating authority. And on such notice of compounding of the contravention being given, the person in relation to whom the contravention is so compounded shall be discharged. So, my lord, clearly it has to be done. It can first. I shouldn't overstate, my lord. First, I want to say, my lord, clearly this shows that it can be done before the adjudication is over. Clearly. And my learned friend's contention is that it can't be done before the adjudication is over. So that argument must fail, my lord. Sir. Those, my lord, are preliminary replies to what my learned friend has argued, primarily. I now wish to, my lord, put forward what was my submission before the learned single judge, my lord. We submitted, and it was accepted, that on a reading of various provisions of the statute, not the rules. I did not rely on the rules, my lord. My learned friend, my lord, is not right in saying that I relied on any rule, neither 2004 nor 2000, except 6 and 7, because that was very important. It is my submission, my lord, that if we look at several provisions of the Act, it becomes clear that the purpose of this Act is to allow compounding prior to adjudication and not allow it after. That is, my lord, the submission. Based on the provisions of the Act. Right here, my lord, I would like to say that the learned single judge added one more component to this argument in her judgment. She said that that is the position even under the concept of the nature of compounding. My lord said that the nature of the process of compounding is such that it should happen before the adjudication is complete. So the nature of the process, the various provisions of the Act, all lead us to that conclusion that it should not happen after adjudication. This is now, my lord, what I will try to establish by first taking your lordship through the sections once. And I propose to do it, my lord, in a particular order because the Act has a time frame, as a timeline also. And that timeline also, my lord, is of significance. And that will explain to your lord, my lords, my lord, why the learned single judge said that the timeline will be set at naught if this argument is accepted. So we have to start with, my lord, 13. Page, my lord, 15 of the compilation.
Yes.
Penalties: if any person contravenes any provision of this act or contravenes any rule, regulation, notification, direction, or order issued in exercise of the powers under this act, or contravenes any condition subject to which an authorization is issued by the Reserve Bank, he shall, upon adjudication, be liable to penalty up to thrice the sum involved in such contravention, where such amount is quantifiable, or up to 2 lakhs rupees where the amount is not quantifiable, and where such contravention is a continuing one, further penalty shall, which may extend to 5,000 per day after the first day, etc. So that's what happens if you contravene. If you contravene, then subject to an adjudication, you will be liable to pay penalty. Then I am not, my lord, taking your lordship to 1A onwards, because it's not primarily necessary to understand the scheme of the act. Then comes, my lord, 16 actually, appointment of adjudicating authority.
Yes.
For the purpose of adjudication under section 13, the central government may, by an order published in the official gazette, appoint as many officers of the central government as it may think fit as the adjudicating authorities for holding an inquiry in the manner prescribed after giving the person alleged to have committed contravention under section 13, against whom a complaint has been made under subsection 3, hereinafter in this section referred to as the said person, a reasonable opportunity of being heard for the purpose of imposing any penalty. So an authority is set up by section 16, and section 16 also provides that he will hold an inquiry in the manner prescribed against the persons. That is the adjudication. Then, my lord, so therefore, my lord, a contravention, if adjudicated, there will be a penalty. Now come to 14, very important.
Yes.
My lord, it's slightly convoluted, but without too much difficulty, your lordship will be able to see how step by step, my lord, the process has been laid out. 14, enforcement of orders of the adjudicating authority, subject to the provisions of subsection 2 of section 19. Now, section 19 is the appeal provision. Your lordship may quickly just check. Section 19, appeal to appellate tribunal. All right. Subject only to the appellate provision, if any person fails to make full payment of the penalty imposed on him under section 13 within a period of 90 days from the date on which the notice for payment of such penalty is served on him, he shall be liable to civil imprisonment under this section.
Yes.
Once a penalty is imposed by the adjudicating authority, subject only to appeal court setting it aside, he will have to make payment of the penalty on pain of civil imprisonment. Now, this is the kingpin, my lord, on which, my lord, this entire scheme rests. And if my learned friend is correct, my lord, he can, at this stage, without going on appeal, have the penalty set aside. How? It can't be done, my lord. Section 14 says, only appeal will lie, nothing else. No compounding. A compounding authority who is a lower officer will not be able to set aside, my lord, the adjudication order. This is also noted by the learned single judge.
Yes.
So therefore, my lord, the statute is very clear. Apart from an appeal, you have to pay. Finished. Or yes, so, on pain of civil imprisonment.
Yes.
Then, my lord, 8. No, not 8. 14A, yes. The next thing your lordship has to notice, my lord, is 14A 1. Save as otherwise provided in this act, the adjudicating authority may, by order in writing, authorize an officer of enforcement not below the rank of assistant director to recover any arrears of penalty from any person who fails to make full payment of penalty imposed on him under section 13 within the period of 90 days from the date on which the notice for payment of such penalty is served upon him. Everything has a time limit. And this is also only subject to appeal as provided in section 14. Now we come to 19, my lord. I'm not going to 17 because 17 never came into play in this matter. 3A was found to be not violated. But 4 was found. If 4 is found, appeal to a tribunal under 19, appellate tribunal. 1. Save as provided in subsection 2. The central government or any person aggrieved by an order made by the adjudicating authority, other than those referred to in subsection 1 of section 17, that is where the appeal goes to the special director, or the special director appeals, may prefer an appeal to the appellate tribunal, provided that any person appealing against the order of the adjudicating authority, etc., shall, while filing the appeal, deposit the amount of such penalty with such authority as may be notified by the author. So therefore, my lord, he cannot get out once the adjudication is over. He cannot get out of payment of penalty, even if it is by way of deposit, and even if he goes to the appellate forum. Yes. Subsection 2 is also important.
45 days.
Yes, every appeal under subsection 1 shall be filed within a period of 45 days from the date on which the copy of the order made by the adjudicating authority is received by the aggrieved person or by the central government, and it shall be in such form, etc., etc. There is some leeway given that if sufficient cause is shown, then it can be entertained after the expiry of 45 days.
Yes.
45 or 90? 90 is not subject to sufficient cause. And then, my lord, section 35 gives him a right to appeal to the High Court within 60 days, my lord. That's the scheme now. The scheme is complete. It's all time bound.
Yes.
Now, my lord, if your lordship permits, my lord, we had no. I think, my lord, we'll file it. Would your lordship like to look at, my lord, a written note which has been prepared also? It'll just, my lord, shorten the time for making the points, my lord.
Bench and I'll give them one.
Other side.
Yes.
And kindly come straight away to section paragraph 11, because, my lord, I have now taken your lordship through the sections and indicated what in my submission is the manner in which the scheme is worked out by the statute in a time bound frame. Now, my lord, I'll place this note, my lord, para 11 onwards. It'll just save some time, my lord.
Yes.
The important thing to notice is that section 14 process for enforcement of orders of the adjudicating authority is only subject to the provisions of section 19 and nothing else. Where an appeal is filed, section 14 makes it clear that full payment of penalty has to be made. This is clear indication that once the penalty proceedings under section 13 comes to an end by the imposition of a penalty, the person who has committed the contravention is bound to make full payment of penalty. It is important to note that once the penalty proceedings is completed and a penalty has been imposed, no amount other than the penalty can be paid by the delinquent. This is a clear indication that compounding proceedings cannot be initiated after the conclusion of the penal proceedings under section 13. My lord, I am drawing conclusions, my lord, in my respectful submission from the scheme that I have already pointed out. Then para 12. The scheme of the said chapter is always time bound. Chapter being, my lord, chapter 4 of the Act. If the person contravening is allowed to file a compounding application after the imposition of a penalty as claimed by the petitioner, the entire process will become open-ended, and the delinquent petitioner will be able to keep the issue at large by neither preferring an appeal under section 19 nor applying for compounding. Once all time limits under the said chapter have been exhausted, the delinquent will be at liberty to start the whole process over. This is in fact what has happened in the present case, where after imposition of a penalty, the petitioner seeks to reopen the proceedings by making an application for compounding. So, my lord, the timeline gets frustrated because he can frustrate it by not filing the appeal and saying, oh, I can still file a compounding application whenever I want.
Yes.
13, my lord. Allowing a person to wait to see what penalty is levied upon him before applying for compounding would go against the concept of compounding altogether. A person cannot take a chance and go for compounding of offences. The compounding of offences is based on the principle of disclosure. The test is whether the applicant is candid in the matter of placing all materials and facts before the compounding authority without in any manner trying to hoodwink the authority to escape his liability. I've given a judgment, my lord, we'll file it before your lordship. Then 14. The above submissions are also supported, para 14. The above submissions are also supported by Rule 6 and 7 of the Compounding Rules 2000. I have not gotten to 2024, my lord. My learned friend need not be afraid. I agree, my lord, that this particular proceedings is governed by Compounding Rules 2000, not 2024. I'm not relying on 2024. Rule 6, I rely on, my lord, the scheme of the Act itself and the nature of the process. Rule 6 makes it clear that when the contravention is compounded, no further inquiry shall be held for adjudication. Rule 7 states that when the compounding has been made after the complaint, the compounding shall be brought to the notice of the authority, and thereupon the person who has compounded the contravention shall be discharged. Rule 6 and 7 make it clear that compounding has to happen before the adjudicating proceedings are brought to an end. Then 15. The form which has to be submitted in order to apply for a compounding under the rules require the persons concerned to accept the existence of not compounding, my lord, existence of contravention, actually. Because he has to say, under section 15, he has to say what is the contravention. Contravention. It would be incongruous to suggest that the person would be at liberty to deny the contravention in a section 13 proceedings and only accept he is in contravention once the adjudication has gone against him and thus ended in imposition of penalty. Then 16. The period mentioned in 16(1) for the purpose of compounding commences from the date of receipt of application by the Directorate Enforcement. The starting point of this period is different from the starting point of the period of 45 days in preferring appeal. So, my lord, this 180 days is the sum total of the time given to him for making the compounding application. Then, my lord, the rest of the paragraph is not important, my lord. The subsequent paragraphs I am not relying upon, my lord, because these are answers to some of the questions which my learned friend had raised before the learned single judge. So, my lord, that out of this note, my lord, I do not wish to place anything further. Now I come to, my lord, some pointed replies, my lord, to what my learned friend has submitted today, which has not already been covered in my submissions, my lord. The first submission I have already, my lord, dealt with, that on the language of the sections itself, it is not correct to say that that compounding can only be done after adjudication. This point, my lord, I have argued in detail. Now, my lord, my learned friend has just 1 minute. So, my lord, I have not, my lord, at any stage relied on 2004 rules, 2024 rules for this purpose. The judgment doesn't say so. Our written submissions did not say so. Then, my lord, the next proposition is, my lord, that he has the option of filing a compounding application if he doesn't file an appeal. My lord, I respectfully submit, my lord, without filing an appeal, he can never get rid of the adjudication order. Compounding authority or order cannot come and remove the adjudication order. Both orders will then remain, and we will have the very aspect, my lord, which the learned single judges has, my lord, referred to. Now, my lord, the last point was, my lord, natural justice. Since that question, my lord, is directly being page 81, 6.4. In case where adjudication has been done by the Directorate of Enforcement and an appeal has been filed, no contravention can be compounded. Please see, my lord, that if my learned friend is relying on 6.4, it covers both situations. Adjudication has been done and appeal has been filed, both. Now, my learned friend relies upon section rule 11. Rule 11 was, my lord, in page 70. So the 2000 rules, my lord, had rule 11. No contravention shall be compounded if an appeal has been filed under section 17 or 19. My learned friend wants it to be read in the converse. He is not relying on this rule as it stands. He relies on it to establish the converse, that therefore, till appeal is filed, a contravention can be compounded. Now that goes against the scheme of the Act, my lord, that interpretation of the rule. Rule will not take priority, my lord. The scheme of the Act will take priority. The rule will have to be interpreted in that light. That's my submission relating to 11. And I've shown, my lord, that these are the rules which are explained by the Reserve Bank of India, though of course explanations must of course be subject to your lordship's interpretation of the Act and the rules. But these master directions have been stated to be of statutory nature. Doesn't mean it can't be interpreted by the court. It just means, my lord, that these master directions are not just office orders. They are, my lord, stated to be in several judgments, my lord, but I'll only mention one judgment. What is it? Patterson. The directions also has some statutory force. And if that is so, my lord, 6.4 should also be read in favor of, my lord, the statutory interpretation that I am canvassing, because that talks about the adjudication as well. Yes. My lord, the proposition can be found, my lord, in 2002, 1 SCC 367. Yeah, 2002, 1 SCC 367. This is the central bank versus revenue. Yeah. Though primarily this is for the interest. Judgment is relied on the interest basis. Yes. No, this is Lahoti. At page 403, para 5.
55 point.
Page 403, subpara 5 of paragraph 55. Para 55, subpara 5, page 403. I'll just read this, my lord. The Reserve Bank of India is the prime banking institution of the country entrusted with the supervisory role over banking and conferred with the authority of issuing binding directions, having statutory force, etc. So these master directions are all issued first as directions. Just on a point of, my lord, fact, the RBI, my lord, from time to time issues directions and then collects the directions together into a master directions and again issues the master directions. So that, my lord, you will find all the relevant directions on that particular point in one place. Each direction is under the statute, under the Banking Regulation Act, having statutory force. And the master direction is having the same statutory force as the directions have to start with. Now, before I come to the judgment, I'll only, my lord, deal with one more point which my learned friend mentioned in the end, and that is, my lord, the natural justice point. My lord, that question is before your lordship. It has already been answered by the learned single judge. We are on appeal before your lordship, my lord. So therefore, there is no question of now going back to the authority to adjudicate whether the compounding application is maintainable after the adjudication is over. That's the question squarely raised in this proceedings, answered by the learned single judge in one particular way and subject to appeal before your lordship, my lord. So there is it is not to be referred back. The question was not, my lord, whether it should be referred back on facts. Now, my lord, I go to the judgment for a minute.
Mr. Gupta, before you proceed,
yes.
If you come back to 6.4 at page 81.
Yes. Page 81. It also refers to Rule 11.
Yes.
Correct, my lord. Your lordship is right. But, my lord.
And.
Yes. I'll read it again. Let me just read it again. In case where the adjudication has been done by the Directorate of Enforcement and an appeal has been filed under Section 17 or Section 19, no contravention can be compounded in terms of Rule 11.
The next part.
Yes, the applicant shall confirm in the undertaking to be furnished as per Annexure 11 along with the compounding application that they have not filed any appeal under section 17 or
So
19.
this envisages a compounding application post adjudication.
Well, that is why I am saying that if you read it in the context of the first 3 lines, that cannot be the correct
But then
position.
how do you read these last 3 lines?
Millard, if there is, suppose Millard, there is some ambiguity arising because of the last 3 lines, we'll read it literally that you have to do this, that's all.
So if you have to do it,
yes,
if you have to do it,
yes,
then it stipulates you file that undertaking that there is a adjudication by the concerned.
So you have to do that.
So it's post adjudication.
No, of course, post adjudication, you'll also, the applicant shall confirm in the undertaking required to be furnished under Annexure 3 along with the that he has not filed an appeal. He has to do that. That is Rule 11. It does not therefore mean that it was permissible for him to file an application after the adjudication was over, because the first sentence itself says, in case where adjudication has been done and an appeal has been filed, no contravention can be compounded.
You're saying this has to be read
in the context of the beginning. It can't contradict it, Millard. So we'll have to leave it as it is, Millard. We'll just say, yes, you have to do this. That's all. It will not add to the proceeding. Anyway, Millard, kindly see, if you are satisfied that the statute proceeds in a particular fashion, the rule will not make a change, nor will the master directions. Now, Millard, I come to the judgment for a minute, Millard, if your lordship doesn't mind, and that's it, Millard. So, Millard, the judgment is to be found annexed to the memo and also, of course, as an annexure to the stay petition. 234 in the stay petition. Now, I'm just placing some certain paragraphs, Millard. Para 4 first, because the just Millard, it of course makes it clear that the facts have not been gone into, because just like it is happening before your lordship, there also, Millard, since it was a question of law, no directions were given for affidavits. So the factual issues, Millard, were not gone into, Millard. Whether it is a contravention, whether the adjudication order is right.
Admitted in his compounding application.
Yes.
So facts are not disputed in so far
Millard,
as
we are saying that the compounding application is without jurisdiction. So maybe I won't be able to rely upon the compounding application. But nonetheless, Millard, what I'm saying is that the factual matrix is not, it's not, Millard, gone into. Anyway, Millard, let me go straight away, Millard, to paragraph 11 at page 5. Because, Millard, your lordship will find that each and every one of the sections, including section 14, have all been, Millard, gone into in each of these paragraphs, one by one. The rule 11 has been gone into, section 7 of the compounding rules has been gone into, it should be rule 7, Millard. Then rule 4 of the compounding proceeding rules has been gone into. Then 14 is 11, which my learned friend is relying upon. Then 15 is the master directions. Then 16 is, Millard, direction 1 by 1.3. 17 is direction 5.3. Then 5.4, then 6.4, then 7. Having done all that, Millard, this is the problem, Millard. You can't look at the conclusion and say, how did he come to the conclusion? He came to the conclusion after saying all that. Then comes 22. If we now read, Millard, having seen that the learned judge has taken pains to go through each one of the provisions that has been cited by my learned friend, kindly come now to 22. The idea of compounding is to get an issue settled without the parties going for regular trial and adjudication for payment of compensation or fine as applicable. In case there is a provision for compounding, the parties seek to avail of the said remedy only to get the issue settled by way of negotiation without undergoing legal intricacies. By this manner, the usual lengthy process of adjudicating can be avoided. Millard, completely unexceptionable, Millard. This is the concept of compounding. 23. Compounding cannot be claimed as a matter of right, but it's always subject to the legal provisions. Once the offender or contravener agrees to avail of the benefit of compounding, the same implies that the party is agreeable for a settlement and there is no requirement of the issue being taken up for adjudication. The very object of compounding an offense will be frustrated if prayer for compounding is made after the adjudication process concluded. Then 24, my lord, is on facts. 25, I don't trouble your lordship with. Then, my lord, 28. 28 at bottom of the 10th page of the judgment. In the instant case, the offense of the petitioner was compoundable one. The petitioner, though applied for compounding at the initial stage, but did not proceed with the same after the application of the petitioner was returned for want of proper details. It wasn't returned because it was not maintainable or anything of that sort. The petitioner, without raising any objection, participated in the adjudicating proceedings. The participation of the petitioner implies that the petitioner did not want to compound the offense and accordingly proceeded for adjudication. After the adjudication order is passed and the petitioner is found guilty of the offenses, now prayer is being made. Then 29. It appears that the petitioner simply tried to test the waters and see as to whether the adjudication order comes in his favor or not. After the adjudication order went against him and penalty amount has been quantified, the petitioner seeks to proceed with the compounding. Had the petitioner been aggrieved, he would have been required to prefer an appeal because of section 14, which the judge has already seen. And for doing so, the petitioner has to deposit the entire amount of penalty. The petitioner is trying his level best not to pay the penalty that has been imposed and delay the proceeding for an indefinite period on the plea of compounding. Then proceedings under FEMA are required to be initiated and concluded in a time-bound manner. Separate timelines are mentioned in respect of the steps that are to be taken either for adjudication or filing or disposal of proceedings. Contravention which took place in the year 2011 to 13 was detected by the authority and show cause notice issued in 22. After the offense of the petitioner has been adjudicated and penalty imposed, the petitioner would be bound to pay the amount of penalty. Permitting the contravener to avail of the benefit of compounding at this stage would require the entire issue to be reopened all over again. The same will frustrate the whole adjudication, rendering the adjudication process nugatory, and the entire time period consumed for the process of adjudication gets wasted. It is only for the purpose of avoiding the rigmarole of adjudication process that compounding has been incorporated. The moment the contravener forgoes the benefit of compounding, the next step forward is to reach the adjudication proceedings to its finality. Then 32, Millard, this Millard, I am very I wish to submit, Millard, is very important. The order which is executable at present is the order of the adjudicating authority. It will not vanish, Millard. It is an order. Subject to appeal, Millard, that order is executable. Not more than one order of the same set of facts between the same parties can be permitted to be executed is one of the cardinal principles of jurisprudence. If the prayer of the petitioner for compounding the offense after conclusion of the adjudication process is allowed, then there will be two orders. First, the order of the adjudicating authority, and second, the order of the compounding authority. In respect of a contravention, two orders cannot survive. Millard, I respectfully submit, Millard, that this is correct. Which one will be Millard, enforced? The compounding authority does not have the determination or the jurisdiction to amend, cancel or overrule or set at naught the order passed by the adjudicating authority. It is only one order that survives, and that is the order of the authority. The petitioner took the risk and did not proceed, etc. And one more paragraph, Millard, 35. As the said situation was not contemplated in the Act, there was no time limit prescribed within which an application for compounding can be filed after the order of adjudication has been passed. Now that's the only thing now, if my learned friend is correct, and it is possible to apply for compounding after the adjudication. That is the only application for which there is no timeline in this statute. Everything has a timeline. Now we have another possibility which doesn't have a timeline. It'll go on. Penal, it will be open-ended process. This is why, Millard, the learned judge says it will be an open-ended process, and any person found guilty in the adjudication proceedings can seek to file an application for compounding anytime he chooses. Penal provisions of an act cannot be taken so lightly, leaving it in such an indecisive state. By this way, the contravener will remain scot-free and the penal provisions cannot be implemented. The act will be rendered toothless, etc. Millard, this timeline, Millard, he can defeat by simply not filing the appeal and waiting and then saying that, okay, now I'll file a contravention. Well, these are my respectful submissions.
Thank you.
I will be adopting the submissions made by my senior RBI. In addition, I will only take out one point. Only one.
Yes, what you are referring to?
But only one thing I will show, Malad. Malad, you kindly see my notes were at page 70 to 11.
Yes.
Malad, Rule 4 and Rule 5 are the enabling provision for apply for compounding. They to be read with section 50. The Lordship has already seen. Section 15 says that any person can apply for the compounding subject to the provisions. Now, Rule 11, after Rule 11, your Lordship comes to page 17. Your Lordship will find the form of compounding at page 17. Similar to page 70, Lordship kindly turns the page to page 71. Kindly see column 4. This will buttress the argument of my learned senior appearing for name of the adjudicating authority before whom the case is pending. Lordship got it?
Yes.
Now, my lord will kindly take the state petition, page number 129. That page 129 is the first application which they made in January 2023.
Yes.
Now here your Lordship will find column number 4, the same thing, name of the adjudicating authority before whom the case is pending. They have mentioned Special Directorate ER, Enforcement Directorate, Government of India, Kolkata. Because at that point of time it was pending before you. Now this was written, your Lordship has already seen, on the ground that they have not clarified or explained the whole fact. Now the second application they made after the adjudication order is at page 199. Lordship will kindly come to 199. The same column in a different format. They have written at the bottom, they have themselves made a column 4.1. The case of the applicant has already been decided by the learned special director. The column requires you to show where it is pending. So after adjudication, you cannot say it is pending.
Yes.
Now, Malad, another thing. This is one. The other thing, Malad, will kindly see. Page 225 in the state petition. That was the first order passed by the learned senior judge, honorable senior judge, while hearing the paragraph 3. Consequent to the adjudication order, a demand notice dated 17 January 2025 is issued, directing the petitioner to pay a penalty of rupees 10 crore or to produce a copy of the order of the appellate authority dispensing with the depositing the imposed penalty has been issued. This was annexure B10 to the writ petition. Surprisingly, this application before your Lordship ends at page 223 with annexure P9. P10 is not before your Lordship.
Which is P10? This order.
P10 was that demand order issued by the Enforcement Directorate asking them to pay the amount of penalty or to produce the order of appellate authority dispensing the pre-deposit.
Hmm.
I have the new petition copy. If you want, I can show you.
That has not been, that was not annexed.
That has not been.
Anyway, that was.
Anyway, so well, why I highlight this?
Yes.
Why I highlight this? My land senior was referring to section 14, enforcement of an order. My lord, 90 days time has been given, your lordship can recollect 14 subsection 1. That within 90 days either you pay or you face a civil imprisonment. Why? Section 19 provides an appeal of 45 days further continuous. So 90 days legislature has the wisdom has given to the double to the time limit for referring appeal. Now rule 11 is always coming into picture saying why rule 11 is why 6.4 of the master circular says you have to give an undertaking. Well, it cannot be an indefinite as the honorable single judge has said.
Yes.
So that is why when the demand comes before you to pay, you are before the order. When the exit. Very deeply understand.
Yes, Mr. Chidamani, you want to say anything in reply?
Your Lordship, give me about 10-15 minutes.
No problem.
Lord, my first and Your Lordships, hear me for 15 minutes now, I can complete it.
Yes,
I thought Your Lordship may have other things to. Lord, the first and according to me, the most compelling argument is if Your Lordship holds that no compounding is possible after adjudication, Rule 11 and paragraph 6.4, which is statutory, are completely otiose and erased from the rule book and the direction. If my learned friend's argument is accepted, just see Rule 11 and paragraph 6.4. Again, Rule 11 is at page 70. Both are statutory. Master direction is statutory. My learned friend relied upon the central bank case. Now kindly see. Rule 11 at page 70. No contravention shall be compounded if an appeal has been filed. It should have simply said, no contravention shall be compounded after an adjudication order. No contravention shall be compounded if an appeal has been filed. As my Lord Justice Mitra mentioned, an appeal can only be filed after an adjudication order. An appeal cannot be filed without an adjudication order. This is further strengthened by paragraph 6.4, which is at page 81. My learned friend correctly started by saying, I'm not relying upon any rule, I'm not relying upon any direction, I'm only relying upon the section. But then Rule 11 is made by the central government. Master direction is issued by the RBI. Both are statutory. Now, having read Rule 11, please read 81, page 81, paragraph 6.4 immediately. I'll read it together, Miller. No contravention shall be compounded if an appeal has been filed under section 17 or 19. In case where adjudication has been done by the Directorate of Investment and an appeal has been filed under section 17 or 19, no contravention can be compounded. This is exactly Rule 11. I'm sorry, Miller. I apologize. So Rule 11 is reproduced in slightly different language. Rule 11 says no contravention shall be compounded if an appeal. In case where an adjudication has been done by the Directorate of Enforcement and an appeal has been filed, no contravention can be compounded. It's the same. It contemplates a contravention, an adjudication, and an appeal may be filed, may not be filed. My learned friend, with great respect, tried to get over it by saying, in case where an adjudication has been done, an appeal has been filed, what he misses is the cumulative condition, and in case where an adjudication has been done and an appeal has been filed, no contravention can be compounded. Simply, textually, literally, the meaning is, if an appeal has been filed, you cannot compound. Then a learned friend said, which is, I think, my lords asked, this Annexure 3 undertaking is practically, if his argument is accepted, is irrelevant. The applicant shall confirm in the undertaking required to be furnished, along with a compounding application, that they have not filed an appeal. If no appeal is possible, why should this annexure be there? If after adjudication, no compounding is possible, that is his premise. If after adjudication, no compounding is possible, why have a form? And why it requires an undertaking? I have not filed an appeal. Because his premise demolishes everything. If an adjudication order is passed, no compounding is possible. But then this says, if an adjudication order is passed, you must give an undertaking that you have not filed an appeal before filing a compounding. Therefore, my lord, the only conclusion, literally, textually, of Rule 11 and paragraph 6.4 is that a compounding is possible after an adjudication order. My lord, my argument has been misinterpreted. I'm not saying in every case, no compounding is possible before an adjudicating order. No, I didn't say that. If one section is violated and there's no confusion about who the compounding authority is, you can file a compounding straight away if you think you don't want to go through an adjudication. In some cases, in this case, I don't know who should I compound. He says, you file 2 compounding applications. Compounding, my lord, is a purely matrix. Now kindly see that at page, the matrix is at page 83. Compounding is purely a matrix. Each contravention, the compounding amount is mentioned, existing formula. Now kindly come to 4, which is relevant in our case. All other contraventions, including contraventions of FEMA, etc., 50,000 rupees plus given percentage, first year 0.5, second year 0.55, third year 0.60, 4 year 0.65, 0.607, etc. It's a purely arithmetical calculation. You may reject the compounding application for whatever reasons, but if you are compounding it, it's purely a matrix. Then my learned friend said, compounding is setting aside an adjudication order. No, my lord. Compounding is a settlement. Black's Law Dictionary defines compounding as a settlement, a settling of an offense. Instead of paying the penalty adjudicated, it is a settlement. The key word used is kindly see compound. The third meaning, it is settle. It's got different meanings, my lord. Kindly see the third meaning. It's a settlement. I don't want to contest in an appeal. I am undertaking, I will not file an appeal. I have not filed an appeal. Third meaning, compound. The first meaning, second meaning, and the third meaning, to settle. It is a settlement. It is, I have been imposed a penalty of 10 crore. I can go in appeal. I can go in second appeal. In this case, only first appeal. And then I can go in a writ petition. I can go to a writ appeal. I can go to the Supreme Court. Why drag this matter? Will you agree to settle it? According to the matrix, I'll pay so much. Will you agree to settle it? They may have good reasons or sufficient reasons to reject my compounding offer. But if they want to settle it, they have to pass an order of compounding. It is not setting aside the adjudicating order. It is settling a dispute. That is my third submission. The first, my lord, is that if his argument is accepted, Rule 11 and 6.4 have to be raised. The second argument is compounding is a matrix and it's a settlement, and Black's Law Dictionary supports that. Just a moment. Why should a form be prescribed? Why should an undertaking be required? If his premise is the first and last premise that no compounding is possible after adjudication, then why should a rule be made? Why should a direction be issued? Why should a form be prescribed? And why should an undertaking be asked? The rule, direction, form, and undertaking make it absolutely clear that there is life after adjudication in the form of compounding. He says adjudication brings you a death for compounding. Then why should a rule, form, direction, form, and undertaking be prescribed? The next submission, my lord, is important. Now kindly see the use of the word contravention. He is reading contravention as allegation. Now kindly see the section. No, first section.
13.
First section is 3A, no? No, 3 is the offense. 13. Now kindly see. 13. Offenses are set out. Kindly see the language of 13. If any person
13. Yes.
Contravenes any provision of this act. Who can find the contravention? It's only the show cause notice authority who can say alleged contravention. I will deny, naturally. And I must be found guilty of a contravention. It's only when I'm found guilty of a contravention, a penalty arises. So there must be an adjudication for the purpose of contravention. Now kindly see the language of other sections. 15. Any contravention under section 13. That if I'm found guilty and I'm found to have contravened section 13, then an application may be made to compound. Any contravention under section 13 So the word contravention means somebody must find me guilty of the section. Now my learned friend says, if I think I have a good case, I will face the show cause notice. If I have got a bad case, I'll go for compounding. You know, what my view is, what my lawyer's advice is not what the adjudicating authority is bound by. I may think I have a good case. He may say, you have contravened. I may think I have a bad case, but he may think that you are not guilty of the contravention, exonerate. For example, here the most serious violation is 3A. 3A, he exonerated me. Now, should I anticipate that I have a bad case on 3A and therefore let me compound it? He found it to be exonerated. 3B is exonerated. Only regulation 4, which is a minor defect, on merits, my lord, I may have, but we are not on merits. Only for the purpose, I opened the bank account with the permission. I remitted the money with the bank with the permission. I traded in securities without the permission. They say you borrowed money from the bank and used it for along with your own capital, and that's not without with permission. That according to me, is the simplest allegation to explain. But that I've been found guilty of that. So I can't decide for me what the adjudicating authority will say. I have to wait to see the adjudicating authority. He may exonerate me of all the allegations. If he exonerates me of all the allegations, there's no question of compounding, no question of appeal. If he finds me guilty of any particular contravention, then I can decide, should I go to the ED, should I go to the RBI, depending upon the contravention. Is the RBI likely to take a favorable view in view of past precedents? Is the ED likely to take a strict view, etc.? It's only after adjudication. Only after adjudication that decision can be taken. I can't take the decision for myself and hope that the adjudicating authority will decide in my favor. Then, my lord, the last argument of my learned friend, which is prominent in his argument, but the learned judge has not relied upon that line of argument, that the timelines will be violated and the adjudicating order will be set aside. Now, kindly see the section. Completely misplaced argument, with great respect. If I don't file an appeal, if I don't file for compounding, the adjudicating order will be enforced in 90 days. Section 14. Therefore, there is a time limit. He says you can keep it open for endlessly. Where is the question of keeping it open? Section 14. Subject to the provisions of subsection 2 of section 19. That is an appeal.
Yes.
If any person fails to make full payment of the penalty within a period of 90 days, he shall be liable to civil imprisonment. So I have got 90 days, only a 90-day window. I'll have to either file an appeal or file the compounding. And when compounding is filed, it's not as though, as my learned friend says, and he, unfortunately for me, persuaded the learned judge to agree that I can drag on the proceedings. Compounding is also limited to 180 days. Now, please see, which is the rule, is it? Huh? The rule, Section 14 imposes a 90-day limit upon me to either file an appeal or file a compounding. And the rule, Rule 8 at 67, Rule 8, Rule 8 starts at 69. The compounding authority may call for any information. The compounding authority shall pass an order of compounding after affording an opportunity and not later than 180 days from the date of the application. So there are definite time limits. 90 days for me to make up my mind whether appeal or compounding. If a compounding is filed, 180 days. So assume I file the compounding application on the 89th day. It's only a 180 plus 89, 269 days. It can't be endlessly, Miller. It's not without a time limit. What else? And then my learned friend says, kindly see 15.2 also. Where a contravention has been compounded. So a maximum of 89 days for me to file an appeal, or appeal is 90 days, is it? Appeal is only 45 days. Compounding is within the 90-day limit, because 90th day, the civil imprisonment. Assuming I take 89 days and 180 days for the compounding authority, 15.2 says, where a contravention has been compounded, no proceeding or further proceeding, no proceeding, further proceeding, civil imprisonment, enforcing and collecting the money shall be. Therefore, there are definite time limits. 45 days for an appeal, 90 days for me to make a compounding, because otherwise the guillotine will fall and the civil imprisonment will follow, and 180 days for the compounding authority. If 180 days he passes an order of compounding, no further proceeding. It's not endless, Miller, as a learned judge thinks that I can drag it endlessly. Therefore, my submissions are the following. I have given written submissions, my lord, which is on the compilation. Take that page. The compilation, the written submissions are at page 228, which you may your lordships may 228. All that I have argued is there in the written submissions filed before the learned judge. In paragraph 9, I refer to Rule 11. And then in paragraph 10, I say appeal is 45 days. And I've set out Rule 11 and paragraph 6.4. And I've also shown that the 2000 rules will apply. All that is there. Finally, my lord, my learned friend for the ED said, I have not filed the demand notice. My lord, it was filed before the learned judge as annexure 10. Somehow in the compilation, in the writ appeal, this 310 has not been included. It's not as though it's been suppressed. P10 is a demand notice for 10 crore, which I amended the writ petition and filed a fresh writ petition to quash this. This is no mystery in P10. No mystery in P10. This is after the adjudication order, they demanded after filing of the first with the 30030, this demand notice came. Therefore, I amended the writ petition and filed a fresh writ petition and withdrew the earlier writ petition. So my respectful submission, textually, literally, contextually, and in the scheme of the Act, irrespective of the so-called timelines, I have a right to file a compounding application after adjudication. It does not mean in a given case, you cannot file a compounding application before adjudication. He may. But in a given case, and especially in this case, I am entitled to file a compounding application after the adjudicating order, and your lordships have to give a meaning to Rule 11 and paragraph 6.4. Otherwise, Rule 11 and paragraph 6.4 will be completely otious and erased. And no prejudice is caused because the adjudication order is there. The compounding application will be dealt with. If they have got good reasons to reject it, they will reject it. But if they are compounding, they have to pass an order within 180 days after giving me an opportunity. And the compounding is a matrix, and I will pay the matrix. I settle the demand for 10 crore by paying according to the matrix. Therefore, there's no heavens are not going to fall on the RBI or the FEMA if offenses are compounded. And contraventions are compounded, not allegations are not compounded. Contraventions are compounded. Those are my submissions.
Thank you.
My written submissions may be taken as my written submission. If my learned friend said he may cite some judgments, if he cites such judgments, I'll give
No more.
You said
No, that CBI was the only one, which I was not being able to find.
Which one?
Central Bank.
Central Bank.
And there's one other I read from that Anil Chanana. We'll find that judgment which is mentioned in paragraph.
Which one?
The note we gave you. Yes. Okay, well, that paragraph, my lord, referred to this judgment which we are filing also.
What is that judgment? Give me a copy.
Yes, I'm giving it.
Central Bank doesn't require any rebuttal, my lord. What is this?
Anil Chanana.
What are you referring?
What is compounding?
Yes, where does it say?
We have given this.
Which paragraph?
Based on the principle of disclosure.
Which paragraph are you reading?
Para 15.
You are for 3 and 4. You are for
15 and 16.
My lord, the ED's role came to an end, if I may say with respect. Your lordship may hear him. ED's role came to an end when 3A I were exonerated. There's no role for ED.
When I started that.
What is this, 176? No, that doesn't.
Thank
you. This is written submission.